We're dealing with item number 7 first. Item 7, EU scrutiny. I want to record the decision taken by the Committee on EU legislative proposals. The Committee agreed that Schedule A, item COM 2018-646, warrant further scrutiny. And the Committee then agreed that Schedule A, items COM 2018-537, 576, 601 and 614 do not warrant further scrutiny. Full details will be published on the website. Item number 8 then, we're dealing with the governance and regulation of receivers. Ms Helen Corley, Principal Officer, Ms Tara Coogan, Principal Officer in the Department of Business, Enterprise and Innovation, and Mr Conor McKenna, Assistant Secretary General, Mr Seamus Carroll and Ms Madeleine Reid. You're all very welcome to the committee this morning. Before we begin, I want to advise the witnesses that by virtue of Section 17(2)(I) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. If you are directed by the committee to cease giving evidence in relation to a particular matter, and you continue to do so, you are entitled thereafter to a qualified privilege in respect of your evidence. You are directed that only evidence connected with only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person, persons or entity by name or such a way as to make him or it identifiable. Members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against a person outside the Houses or an official either by name or in such a way as to make them identifiable. I want to invite Mr McKenna to make an opening statement, please.
Good morning, Chairman and members, and thanks very much for the opportunity to come along today to talk to you on this subject of receivers and the whole regulation of receivers. Just very briefly to introduce myself, Conor McKenna is my name. I'm the Assistant Secretary responsible for civil law reform and courts policy in the Department of Justice, and I'm accompanied on my right today by my two colleagues, Seamus Carroll and Madeleine Reid. And Seamus Carroll is, among other things, responsible for the area of land and conveyancing law, and Madeleine Reid is responsible, among other areas, for the areas of insolvency and bankruptcy and related matters. I won't keep the committee too long, Chairman, but I suppose just to start at the most fundamental level in relation to mortgages, they are there to provide lending institutions with security for their loans, and in the event of financial difficulties resulting in default by the borrower, the lending institution claim on the secured property takes precedence over the claims of other creditors. And the appointment of one of these receivers is one of the principal remedies available to lending institutions in the case of mortgage default, and where the lender doesn't wish to take possession of the mortgage property. In such cases, the alternative remedy of appointing a receiver to ensure more efficient management of a business, such as a shop or a hotel, or to receive rents where housing accommodation has been leased or let to tenants, may be a more effective option. In this latter case, the receiver's main task will be to repay the mortgage from the proceeds of the rental income. The appointment of receiver doesn't normally arise in the case of a borrower's principal private residence, which I think is a key issue, but rather in the case of commercial property, including buy-to-let or BTL premises, where a borrower has mortgages over several properties. The appointment of the receiver facilitates a more orderly approach to the management or disposal of the premises. As Professor John Wiley points out, he is, as you may know, is the author of the classic text on Irish land and conveyancing law, indeed. But as Professor Wiley points out, in Irish land law, there are several sources of appointments of receivers to land, and the position of the receiver, particularly in terms of his duties and powers, will vary according to that source. Provision for appointment of receiver in the case of default is normally contained in the mortgage contract, especially in the case of commercial property. Again, I think that issue, that point about the contractual basis for most or many receiverships is a critical item as well. Professor Wiley identifies categories of receiver as a fixed charge receiver who is appointed over specific mortgage property, such as a receiver is entitled to collect any rent. Such a receiver, I beg your pardon, is entitled to collect any rental income. And then a receiver may be appointed to manage the mortgage property where the objective is to rescue the business if possible. Another form of receivership arises where court assistance is sought by a creditor who has been unable to execute a judgment obtained against the debtor by other legal means, arising from the fact that receivers are generally appointed under the terms of the mortgage contract rather than on application to court. Detailed information on the number of receivers appointed and the properties to which they have appointed is not available. And then just to refer a little to, because I know the committee's invitation very specifically referred to the two acts, the Conveyancing 1881 Act and the Land and Conveyancing Law Reform Act. Apart from the express power to appoint a receiver that is normally reserved in the mortgage contract itself, lending institutions have had a statutory power going back to 1881 to appoint a receiver to land. Section 19 of that 1881 Act has a statutory power which permits a mortgagee to appoint a receiver over the mortgaged land, and this power has been carried over into Section 108 of the Land and Conveyancing Law Reform Act 2009, which again, as you probably know, is an act which consolidated and reformed many hundreds of years of land and conveyancing law. The power to appoint a receiver under Section 19 of the 1881 Act and Section 108 applies generally to legal mortgages and registered charges. Under the 1881 Act, which applies still to pre-2009 mortgages, the power to appoint a receiver arises when the mortgage money became due but is not exercisable until default occurs. Under the 2009 Act, the power vests when the mortgage is created, but again can only be exercised in the event of default. The main function of a receiver in these cases is to manage the mortgage property and to use the rental income to repay the mortgage. The 1881 Act also provides that a receiver shall have the power to demand and recover all the income of the property, and this power is also carried over into the 2009 Act. On regulation of receivers, receivers appointed to corporate entities are, as my Department of Business, Enterprise and Innovation colleagues will discuss with the committee in due course, are subject to regulatory provisions set out in the Companies Act 2014. Part 8 of that Act also sets out requirements governing the appointment of receivers and their statutory powers and duties and regulation, etc. These statutory provisions do not apply in the case of receivers appointed to mortgage property held by non-corporate entities. While neither the 1881 or the 2009 Acts contain provisions in respect of regulation of receivers, the provisions of that should be, my apologies for the typo, that should be the provisions of the 2014 Act will apply where the mortgagor is a corporate entity. And then under obligations on receivers, under existing law, including relevant case law, a receiver appointed to mortgage property is subject to a number of important obligations. A lending institution must act in good faith and fairly when appointing a receiver. The lender must not act in a manner that unfairly prejudices the borrower. On his or her appointment, the receiver is also obliged to act in good faith both to the lending institution and the borrower in his or her management of the mortgage property, and where a receiver chooses for whatever reason to exercise a power of sale, he or she is obliged to obtain the best price reasonably obtainable for the mortgage property for the benefit of both the lender and borrower. The receiver must act as a reasonable person would act in selling the property. The receiver I think this is an important consideration. The receiver and any agents employed by him or her for the purposes of exercising his or her functions as receiver will be held liable for the commission by them of offences whether against an individual under the Non-Fatal Offence Against the Person Act or 97 or otherwise under the Criminal Justice Public Order Acts. Enforcement of those statutory provisions obviously is a matter for the Gardaí and the DPP. In relation to possible licensing reform, and I'm nearly finished as you can see, Chairman, during topical issues debate recently, which concerned events outside premises in North Frederick Street in Dublin, the Minister for Justice and Equality referred to possible changes to licensing requirements for those involved in the execution of court orders. He stated that while matters concerning the enforcement of court order are a matter for the courts, consideration was being given in the Department to the matter of oversight, and this could include the introduction of a licensing regime for personnel directly involved in enforcement actions. One possible option to be looked at would be to extend this licensing remit of the private security authority, which operates a licensing system for the private security sector, to such persons. And by such persons we mean, of course, security type personnel who are there with the receivers, and sometimes with receivers when they're executing their powers. An examination is currently underway and recommendations will be submitted to the Minister in early course in relation to this. Finally, just to refer to the work which has been going on in the Department of Housing, Planning and Local Government, established a working group on receivers last year to examine scope for amending legislation to provide for greater protection of tenants' rights during the receivership process under Action 5 of the Strategy for the Rental Sector. The appointment of a receiver to a buy-to-let property can create great confusion and concern for the tenants of such properties, and it is important that their interests and rights be protected as well during the receivership process. The Department of Justice, together with our colleagues from other departments, including the Department of Business, Enterprise, Innovation and Finance, and the Office of the Attorney General, has participated in this work group. And the objective of this initiative was to improve the protection of rights of tenants during the receivership process, and particularly in relation to the discharge of landlord obligations by receivers. The working group sought legal opinion on feasibility of amending legislation to provide for greater protection of tenants' rights during the receivership process, and the final report of that working group is being prepared at present for presentation to the Minister for Housing, Planning and Local Government, I understand, in the very near future. So we're mentioning that because I am aware that this particular aspect has also been a key element of the public discourse, if you put it that way, about receivers, particularly where receivers are pointed to buy-to-let properties or groups of them where there has been a default on the mortgage by the buy-to-let lender. So finally, Chairman, thank you for the invitation to talk here today and to answer questions, and we're quite happy to help the committee in any way we can.
Thank you very much, Mr. McKenna. Ms. Corley, can your opening statement, please?
Thank you, Chairman, and good morning, everybody. I'm Helen Curley, and I'm a Principal Officer in the Company Law Unit of the Department of Business, Enterprise and Innovation. To my left is my colleague, Tara Coogan, who's also a Principal Officer in the Department. I wish to thank the Committee for this opportunity to address issues concerning the governance and regulation of receivers in the context of the Companies Act 2014. At the outset, and as Mr. McKenna has emphasised, it is important to state that the principal source of law relating to receivership is contract law. Receivership is a long-standing legal mechanism for the enforcement of security. By far the most common method of appointment of a receiver is under the power contained in a debenture. A receiver is an appointed person whose duty is to receive a debtor's assets and property for and on behalf of a creditor who is entitled to take them in satisfaction of the debtor's obligations pursuant to a written agreement. Parties to a contract, e.g. a company and a lending institution, agree that one of the terms on which the company borrows money is that in the circumstances specified in the agreement, the lending institution can appoint a receiver over its assets. The parties have freedom to contract and agree contractual terms, including in relation to the appointment of a receiver. While the terms on which a receiver can be appointed may vary from one debenture to the next, according to Ford, Kennedy and Sims' law of insolvency, they generally include the following events: whenever the principal sum due under the agreement becomes payable, whenever the company fails to pay any instalment or the principal sum or the interest due under an agreement, whenever the company contravenes covenants in the security instrument, whenever the company ceases or threatens to cease its business, whenever a resolution is passed, a petition presented or an order is made to wind up the company, whenever the company acts in such a way as to jeopardise the security created by the debenture, whenever any prior debenture becomes enforceable against the company. There are advantages to a contractual receivership, as it avoids the need for the debenture holder to go to court to enforce the security, and therefore saves costs which the debtor would have to pay. Receivers may also be appointed under specific statutory powers, such as that contained in the Land and Conveyancing Law Reform Act 2009, or by the High Court under its equitable jurisdiction under the Supreme Court Judicature of Ireland Act 1877. Where a receiver is appointed by the High Court, his or her powers will be dependent on the court order of appointment. A receiver's primary duty is toward the debenture holder who has appointed him or her. Receivers will generally have the power to sell the secured assets with a view to paying off the debt owed to the debenture holder. A receiver manager will often have the power to carry on the business of the company, to borrow money, to employ or dismiss employees, to compromise debts of the company, and to insure and repair property. Section 437 of the Companies Act 2014, which I'll refer to subsequently as the Act, confers statutory powers on receivers of the property of a company to do certain things and is intended to alleviate many of the problems which may arise from poorly drafted debentures. Examples of these things include the power to enter possession and take control of the property, to lease, let on hire or dispose of the property of the company, to grant options over the property of the company, to borrow money on the security of the property of the company, to repair, renew or enlarge the property of the company. It is important to point out that these powers are subject to any provision in the instrument under which the receiver was appointed, which limits the receiver's powers in any way, again underlying the essentially contractual nature of receivership. For example, if the agreement provided that the receiver was not to borrow money, the Act would not prevail over that restriction. A receiver is very different from a liquidator or an examiner. A liquidator has the task of winding up the company, realising its assets and distributing those in accordance with law. An examiner is appointed for the purpose of examining the state of company's affairs and secondly to put together some compromise or scheme of arrangement which may facilitate the survival of the company and then reporting to the court. A receiver appointed on foot of a debenture has a much narrower function, i.e. the principal task is to secure the assets of the company which have been mortgaged or charged in favour of the debenture holder which appointed him or her, and realise those assets so that the secured creditor's debt is repaid as quickly and as efficiently as possible. The Act sets out a number of duties that a receiver must comply with. Of these duties, one of the most often cited is that of a receiver in selling the property of a company. Must exercise all reasonable care to obtain the best price reasonably obtainable for the property at the time of sale. This statutory duty makes it imperative that the receiver obtains expert legal and valuation advice in relation to the sale of the property consistent with that duty. In addition, he or she must give notice to the company's creditors if he intends to sell by private contract a non-cash asset of requisite value to an officer of the company. There are provisions relating to the regulation and governance of receivers of the property of a company in the Act. The following are illustrative examples. When a receiver is appointed, the Registrar of Companies must be notified within 7 days of the appointment and must also be notified when a receiver ceases to act. In addition, every business letter, order for goods or invoices issued by or for the company or the receiver must state that a receiver has been appointed. Failure to comply with these requirements is a category 4. That's the most minor offence within the fourfold classification of the company's law offences set out in section 871 of the Act. The Act provides the receiver must make certain information available to the company and to the Register of Companies. In addition, there is an obligation on receivers to send periodic accounts to the Register of Companies. Breach of these requirements is also a category 4 offence. A receiver must also report to the Director of Public Prosecutions and to the Director of Corporate Enforcement if it appears to him or her that a past or present officer or member of the company has been guilty of an offence in relation to the company. Section 433 sets out the category of persons who are disqualified to act as a receiver of a company, e.g. a non-discharged bankrupt, an employee or officer of the company concerned, or a person who was such within the period of 12 months before the date of commencement of the receivership. Certain specified family members of the officer of the company concerned are also disbarred. Body corporate cannot be a receiver of the property of a company. Receivers' fees, section 444 of the Act, allows a liquidator, a creditor or a member of a company to apply to the High Court for an order to fix the amount to be paid to the receiver, notwithstanding that his or her remuneration has been fixed by the instrument appointing him or her. Section 446 of the Act provides that the Director of Corporate Enforcement may, where he or she considers necessary or appropriate, request that the receiver produce to the Director the receiver's books for examination, either in regard to a particular receivership or all receiverships undertaken by this receiver. Again, this failure to comply is a category 3 offence. The Court may, on cause shown, remove a receiver and appoint none, and may end or limit a receivership on the application of a liquidator. That's the end of my initial presentation. Thank you very much for your attention, and we will be pleased to address any questions in relation to the governance of receivers in the context of the Companies Act 2014.
Thanks very much, Ms. Harley. Deputy McGrath.
Thank you, Chair. I'd like to welcome the officials before us and thank you all for the opening statements. Yeah, it's certainly a complex area, and it seems that much is determined by the basis on which the receiver is appointed, whether it be the mortgage, the debenture loan, is there a legal basis under the Companies Acts, and so on. So it seems to be quite varied in terms of the basis and then the impact that that has. So maybe just to start with, on the buy-to-let property issue that you referred to, Mr. McKenna, in relation to tenants' rights. So currently the appointment of a receiver to a buy-to-let property, and we know that has happened in many cases involving several different banks. The basis of that currently derives from the mortgage contract. Is there any statutory basis to that?
There is a statutory basis in both the 1881 Act and the 2009 Act for it, but that basis can be adjusted or otherwise in terms of the actual contract between the parties and the mortgage. I might ask Mr. Carroll just to come in on that, if that's okay.
So the appointment of the receiver when it comes to housing and accommodation is normally to buy-to-let premises. As Mr. McKenna has said, receivership is not appropriate in the case of a principal private residence of an individual. So the receiver, when appointed, has a duty of care both to the lending institution who has appointed the receiver and also to the borrower. So the receiver must act in a fair and proportionate manner vis-à-vis both the lender and the borrower. And so the current law, land and conveyancing law, does not specifically refer or cover the role of tenants in any buy-to-let property. Now, tensions and potential conflict may arise because the role of the receiver is to manage the property, but at a certain stage the receiver may move to sell the property. And the obligation on the receiver then, as has been said, is to obtain the best price reasonably obtainable for the property. That is a strict obligation and has been interpreted by the court in a strict manner. Now, if the buy-to-let property is in a residential area, for instance, likely buyers will want to use this as their residence. So the best price reasonably obtainable for that property will normally require vacant possession of the property. A potential buyer will not wish to buy property with tenants if they want accommodation for themselves. So this is where the conflict arises, where the obligations of the receiver are to the lender and to the borrower, and in a way the tenants are caught in the middle in some way. And there is a code of conduct which has been issued by the Banking and Payments Federation of Ireland. It's a voluntary code, obviously, which it's entitled A Residential Tenants Guide to Receivership, and it answers some of the questions that would arise as regards payment of rent, because sometimes the receiver, obviously his task is to service the loan, but sometimes landlords seek to continue to obtain the loan. But
in essence, the power to appoint the receiver it derives from the mortgage contract.
It derives from the mortgage contract, but there is also a statutory part. There is a legal basis. Sometimes the mortgage contract will refer to the statutory power rather than including the
and there's no need to refer to court or anything like that.
No. This is why we lack data, because the receivership is activated under the contract and it doesn't go to court for a court order. So the information on the number of receivers appointed is actually
quite scant. What are the requirements for informing the borrower, the debtor, and for informing tenants of the appointment of a receiver in this case?
There is nothing specific in the Land and Conveyancing Act or in the predecessor Conveyancing Act of 1881 about informing the tenants, but the Code of Conduct, which is a voluntary code, I underline, does advise that the tenants be informed, because the tenants will have to start paying their rent to the receiver, obviously, whose task it is to repay.
When is the landlord informed of the appointment of a receiver?
I'm not aware of when the landlord is informed.
It really depends on the terms of the mortgage contract, if there's an obligation to inform in the actual mortgage contract itself. But one would assume that it should be pretty standard, good practice for that to happen in any event where there's a contractual relationship and a piece of the contract is being invoked like that.
And then just to clarify, under the existing law, does the receiver take on the responsibilities of the landlord? No. In relation to giving notice of termination, returning deposit, etc. So what's the current position when a receiver is appointed?
These are the matters that are being looked at by the committee which the Department of Housing has established, and which the report of which is being finalised right now.
But are you saying the receiver has no responsibilities whatsoever to the tenant?
There are obligations to maintain the fabric of the asset. So therefore, if there are repairs that are required to be carried out, the receiver will have certain obligations, landlord obligations, to maintain the fabric of the building.
What about the notice period then under the Residential Tenancies Act?
I think that this again is one of the issues which has been looked at. There is nothing specific about notice periods. Because, as I mentioned, tenants are not mentioned at all in the 2009 Act or the 1881 Act.
So currently, are you saying that there's no obligation on the receiver to give the tenant the normal statutory notice for the end of the tenancy? Currently,
there is, as far as I'm aware, there isn't a statutory obligation, but that is one of the issues that has been looked at in the group that has been established. The extent to which the receiver may undertake and is obliged to undertake the landlord obligations where there are tenants in.
But at the moment, a receiver could tell a tenant, you have to be out by next week. And legally,
as far as I'm aware, when it comes to the Residential Tenancies Act, those provisions will continue to apply as far as I'm aware.
Sorry, if I could just add.
Yeah.
The issue is that and this is really a matter for the Department of Housing, who would be better
Yeah.
to obviously discuss this with you, so I don't want to be misleading you, but as the Residential Tenancies Act currently stands, a receiver is specifically not seen as a landlord.
Okay.
So that is the issue that they are examining at the moment.
And so the legal obligations that normally apply to landlords do not apply
Under
currently.
that particular Act currently, the answer would be no. Yeah.
That includes notice periods and so on. Okay.
All right.
And does the voluntary code address that issue, albeit on a voluntary basis?
I can circulate this. I don't think it deals more with the payment of rent, I think,
Okay.
and the involvement
And when is this
of
working group going to report and make recommendations?
As I was saying earlier, Chairman, I think that piece of work is virtually finished, and there are some legal issues arising, I think, at the moment where, if something is going to be done from the Department of Housing's perspective, as well as the other departments who are involved, it needs to be done properly and robustly. So my understanding, having spoken to them as recently as yesterday, is that the piece of work is imminent. It has to be obviously presented to Minister Murphy and to go to government, but I think it is a piece of work which will answer a number of the issues that arise around this relationship between the receiver and the landlord.
Are there any required qualifications to be a receiver?
There are in relation to the Companies Act, I think.
I know there are disqualifications,
Yes.
and you touched on those in your opening address, but are there required qualifications, or can anyone call themselves a receiver currently?
There are, as I mentioned, the disqualifications in the Act. There are no positive qualifications, but obviously receivers are subject to a range of civil and criminal sanctions, and they may be disqualified for misconduct. As I said, receivership results from a private contractual relationship between a lender and a borrower. Examinerships and liquidations, on the other hand, affect all creditors and members as they concern the whole of the business. Receivership is a private matter. The receiver is appointed to realise an asset that is the secured creditor has over the property belonging to the debtor. The responsibility for appointing a competent receiver is obviously on the creditor initiating the receivership, and creditors are expected to choose competent receivers because it is their interest to do so. We understand that most receivers are, in fact, accountants, but I have no statistics on that.
And
that's my understanding.
when a receiver is appointed to a business, and I know you'll make the distinction as to whether it's a company or not a company, but in the case of it being a company, then the Companies Act's provisions apply. Who is the receiver accountable to? And what obligation, if any, does the receiver have to the business that is the subject of the appointment? My experience is that no information is shared with the business owner, the debtor, who is the subject of the appointment. They're kept completely in the dark. The business is being run by a receiver, in some cases run into the ground. Fees are mounting and allowed to get to a ridiculous level, and there seems to be no accountability and no transparency around it.
Well, as I mentioned, the primary duty is to the debenture holder who appoints the receiver. There are no provisions in relation to information that a receiver manager, I think we're talking about in this case, has to apply or give to the business owner. Obviously, as I also mentioned, there are certain duties in relation to if he wants to sell the property, and obviously that is the job of the receiver, is to get monies to repay the debt that the business owes the debenture holder. There are duties then, and there is no indemnity for a receiver. He must get the best price, or endeavour to get the best price for the property when he's selling it.
Okay. Final question, just two-part, because I know the Chair wants to move on. In relation to fees, what is the position around the regulation of fees charged by receivers appointed to a business? And secondly, if somebody wants to bring a complaint about the conduct of a receivership, the behaviour of a receiver, where do they go, and what does the data say in relation to complaints taken against receivers, the outcome of those? Have we seen action taken by the Director of Corporate Enforcement and so on against receivers for bad behaviour that contravenes the law?
In relation to the fees aspect, as I mentioned in my presentation, Section 444 of the Companies Act allows a liquidator, a member, a creditor to apply to the court in relation to the receiver's fees, notwithstanding that they may have been set out in the instrument appointing the receiver. The Court's powers extend to fixing the remuneration before the making of the order of the application if the receiver has been paid previously in excess of the amount fixed by the court order may extend to requiring him or her to account for the excess or such part of it that may be specified in the order. However, this power shall not be exercised in relation to any period before the making of the application for the order to fix the fees, unless, in the opinion of the court, there are special circumstances that warrant it, and that's the provision in the legislation. In relation to complaints relation to the conduct of a receivership, obviously, as I've mentioned, a lot of the terms under which a receiver will act have been set out in the terms of the contract. If there are specific offences that the receiver has committed under the Act, obviously there will be a provision for reporting such offences to the Director of Corporate Enforcement. But in terms of the particular offences, for example, there's various reporting offences under the Act that a receiver who doesn't file abstracts, etc., may be amenable for. The Director of Corporate Enforcement can look for the books of the receiver, in particular in relation to a particular receiverships or all receiverships with which the receiver has been engaged. In terms of numbers of complaints, I'm sorry, I don't have that data. But
Thanks.
Can I ask you maybe one from each department to answer the question in relation to your own views, given your knowledge of this area, and in particular the comment that was made when a case was taken before the Master of the High Court by a constituent of mine, which involved property going into receivership, where the Master of the High Court said, and I quote, "I have sympathy for the view that the unaccountable receivership is a licence for theft." What's your view in relation to that, Mr. McKenna?
Can I just jump in first? Just to add to what was said before, under where a receiver is appointed under the Land and Conveyancing Law Reform Act, there is a statutory instrument from 2010, number 655, which specifies that the rate of commission of the receiver may not exceed 5% of the gross amount of money received by the receiver. So a 5% limit is in place where the receiver is acting under the land law provisions.
Okay. Just go back to the original question. Is that in the context of a corporate receivership, Deputy, that you were talking about?
This was in
a company receivership, is it?
No, it was in relation to property,
right.
Mortgage.
Yeah. Well, look. I mean, it goes back to the previous thing in terms of comment. Like, first of all, the receiver in that instance is, in a non-corporate instance, is subject to the criminal law, obviously, in terms of their behaviour. and whether non-fatal offences or otherwise are under the Criminal Justice Public Order. So that, if you like, that's an accountability to the criminal code in terms of their behaviour as a receiver. And equally they would have liability in terms of any other issue that might arise in tort law in terms of their actions. But the question is, the fundamental question is, are receivers in the non-company context accountable, and is there a system of complaints about the behaviour of those receivers? There isn't.
And that goes to the crux of the problem, because I've heard from many people that receivers are unaccountable, unregulated, no licence required, can run up fees and are running up fees because the longer they're there, the more beneficial it is for them. Even though that under the Land and the Conveyancing Act, they're supposed to be acting as an agent for the borrower. We have state institutions like NAMA. Earlier this year we knew that they paid out 129 million to receivers, 15 million alone in Spencer Dock. Now, and I've been raising these issues for the last number of years. The former Minister for Justice, Frances Fitzgerald, in a response to me in 2016 when I talked about the fact that we had a lack of regulation, we had no regulation in relation to receivers. She said at that stage that the Company Law Review Group was looking at the issue. 2 years fast forward, we still have the Company Law Review Group looking at the issue. So, what do we say to people who, receivers, it's not in all cases, receivers are landing in at the dead of night, they're wearing balaclavas, they're changing locks, there's tenants who are paying their rent to the landlord, and these are companies in some cases, who haven't done anything wrong, have their business closed down to them. And we have all of the anecdotal, and it is, I'm not being able to back this up because I haven't investigated, it's not my job to investigate it, but we have all of the evidence suggested to us that these receivers are milking a system because they are allowed to.
Okay, well, I'll let my colleagues from the Department of Business answer in relation to the Company Law Review Group, but however, there's a couple of things here. First of all, the receivers arriving in the dead of night. I don't think anybody can countenance the idea that people would arrive in the middle of the night. I mean, particularly when you're talking about residences, etc., and people who are living in houses. And I think, one can't see why there would be a necessity for that in the first place. There are often or sometimes issues raised about those who accompany receivers or bailiffs or the likes, and the behaviour of those particular people. And as I mentioned, we are in the Department of Justice now looking very pressingly at issues relating to possibly bringing those who work with receivers or sheriffs, etc., in those instances, rendering them subject to regulation under the Private Security Authority. But we're not proposing that receivers would come within that, because the Private Security Authority obviously licenses security people. But to go back to something that Helen said a while back as well, our understanding is that the vast majority of receivers are actually regulated professionals themselves and would be subject to complaints to their professional bodies about their conduct. And I'm not sure whether that avenue is being used, but if, for instance, a receiver, as they often are, is a member of a particular accountancy body with a regulator over it, and depending on what way misconduct is defined in the legislation or charter governing that complaint system, that could be quite a serious avenue of complaint in relation to the behaviour of receivers.
You see, the problem is you've got somebody who has lost possession or lost access to their property, and then you don't have a body that you can complain to. You don't have that overarching regulatory body that is regulating receivers. If we look at, for example, the 2014 Act, and this was kind of touched upon in terms of the qualifications earlier on. There is qualifications set down in section 519 and section 633 in relation to examiners and liquidators, but no qualifications required whatsoever for receivers. None whatsoever. And like we have, and I'm making this comment because there are numerous properties that have receivers appointed that I have no knowledge of, and I presume that that is done in a fair, transparent and decent way. Okay? And I'm not suggesting that the idea of a receivership is wrong, but I am aware of numerous cases where there has been thuggish behaviour, where there has been a behaviour that is not acceptable, where tenants are locked out in terms of their businesses without notice, where their own personal property they have no access to, where the receivers are failing to communicate with the individual over and over again, where we have countless examples of properties being sold below market value and properties being sold below what was offered a number of months beforehand, and other examples where cases where the overall cost, and not just the fee, but when you roll up the whole cost of the receivership, is nearly up to 30% of the actual value that the property was disposed for at the end of the day. And other examples of businesses that one would argue would be a potentially going concern were run into the ground. So, my question here is, when are we going to deal with this? We need to regulate receivers. We need to set up a minimum standard of qualifications, the same way that there is in terms of examiners and liquidators. We need to regulate them, we need to have a governing body for them, and we need to set up very clear structures where people who feel that they have been wronged by receivers, and if you go to this is the madness of this here, that the Conveyancing Act says very clearly that a receiver is the agent for the borrower. We all know that the receiver isn't acting for the borrower. The receiver is appointed by the bank or the institution. In law, it is an agent for the borrower. In some kind of way, you're trying to, what they're supposed to do is obviously run the company or run the business and try and pay back the mortgage on behalf of the borrower. But the reality on the ground in numerous cases is they are working in complete conflict to that. And what is the option for an individual, such as my constituent in the past, is to go to the High Court. That's out of the reach of most people. And so where I really want to get to is the crux of this here, because as I said, I've been raising this since December 2015. We're still, in my view, haven't moved much forward. Has the Company Law Review Group looked at this issue, and is it actually going to take any action in relation to this?
Deputy, I just need to correct something here. The Company Law Review Group is not looking at this issue at the moment, and it hasn't been ever looking at it, and it hasn't been looking at it since 2016. So receivership is not currently on its work programme. So I just want to correct that misunderstanding. In terms of the other aspects that you have raised, in terms of running up fees, all I can tell you is what the legislation provides currently, and I have mentioned section 444 of the Act and the possibility of going to the High Court to have the receivers' fees reviewed. In terms of minimum standards like there are for, qualification standards like there are for liquidators and examiners, again, I've attempted to point out the difference between a liquidator and an examiner, and the more narrow role in a lot of cases that a receiver will have, which is to secure an asset and to sell that asset at the best price obtainable, so that the debt can be repaid to the person or the institution that provided the money. Like Mr McKenna has alluded to the fact that many receivers, and we understand that this is the case, may in fact be accountants and therefore amenable to the professional standards set by their own professional body.
Just if I might just add something here. I mean, like one of the things I suppose we haven't discussed is a lot of the focus of our efforts since 2015 in particular have been around the whole area of dealing with the mortgage arrears and mortgage distress and the insolvency thing, and trying to render all of those pieces more effective, including through the Awalya service and various other pieces. And we have managed to bring about a number of significant successes in that area. In relation to this area, the whole overall question of regulation of receivers as such, I think, as I mentioned earlier, that we did have this working group with the Department of Housing, etc. We've also got very good ongoing contacts with our colleagues in DBEI about insolvency and related areas, and to the extent that there is a perceived significant gap there, it shouldn't be beyond the bounds of possibility that we will also get together and have a good look at that issue. It obviously, the Companies Acts provide for issues relating to receivers, but only where there's companies. There are obviously also small business issues, small and medium-sized business issues, which aren't companies relating to receivers. Then there are individuals who are probably both the tenants in and the owners of these buy-to-let properties, where they may have bought one or two houses and they're now caught in the headlights of a receivership as well as the people living in the houses. So it's not, I think, beyond our capacity as a number of departments who would have various stakes in this to get together and actually look at this issue and see whether there is anything that can be done directly about it. But I would emphasise that all of our efforts so far have been around trying to deal with this issue of chronic mortgage arrears, and huge amount of success, if you look at the numbers, the way things have changed there, have been achieved in that area by very good, effective cross-cooperation between departments. Seamus just wanted to mention something in terms of obligation.
The huge success. You said you've had huge success across that area.
Well, significant success, yeah.
Where?
Well, to put it this way, in terms of mortgage, the progression on mortgage arrears, the level of mortgage arrears has improved quite dramatically over the last 4 or 5 years in particular, and the level of outstanding.
How do you claim that success?
Well, I mean, the economy partly claims it, but we have the Awalya service in place since 2016.
And you think you think the Awalya scheme has brought about this success? There's certainly significant evidence that a number of graphs are turning downwards in terms of mortgage arrears since 2016 but
in particular.
I'm asking you, are you saying that that's the case because of the Awalya scheme?
No, I'm saying it's a contributing factor, as is the improving economy, a contributing factor, as is the legislation we brought in 2015 to remove the bank veto on personal insolvency arrangements, and other legislation that we brought in, including also in relation to the bankruptcy. So I'm not claiming anything in particular, but it certainly looks as if, particularly in recent years, that things, and most particularly things in the chronic area of 720-day plus arrears, are improving significantly. That area has been coming down since 2015, and it was going up.
But you're claiming that as a success, and I'm asking you, claiming it. What gives you what informs you in the view that the departments have had some role in this success?
Well, the fact that Madeleine can give you some headline numbers, but the fact that probably 12,000 to 14,000 people have now availed of the Awalya service in the last couple of years, and a very large wedge of them, if not more than half of them certainly, are in the 720 or chronic arrears area, which are areas which basically had got no engagement prior to that whatsoever. I think that's one quite tangible success. In other words, people in 720-day mortgage arrears, the numbers were growing right up to 2015, and now, for the first time since 2015, large volumes of those people are engaging with assistance services to help them to solutions and are on the route to those solutions.
What does Awanya do for them?
Well, I'll allow Madeleine to explain that to you, Chairman.
Deputy Doherty, you? No, we'll ask Madeleine maybe to answer that question, and I'll come back to you.
Yeah, I do want to come in back on this. The issue, you mentioned that the law reform review group, or the company law review group, isn't dealing with the issue of receivers and haven't been, and wanted to correct that, and that's fine. I mentioned I've been raising this case since 2015. And in 2016 we did get answers from the Minister in relation to the issue of receivers. She says, however, the 2014 Act does not specify any regulatory standards for the appointment of a receiver. The Company Law Review Group is a statutory body which advised the Minister for Jobs, Enterprise and Innovation on the review and development of company law in this jurisdiction. As part of the work programme for 2014-2016, the Review Group is examining whether it is desirable or necessary to further amend company law arising from case law developments and any submission received on matters which have not been addressed in the 2014 Act. Now, the only reading of that is that is exactly what I said was supposed to happen, and you're telling me, Ms. Curley, that you have never looked at this issue. That's on the record of the Dáil.
And that was a response from the Minister for Justice at the time?
Yes.
Right. It wasn't on the work programme.
If I may, the only thing I can think of in relation to that particular answer is it may have been that it was as a headline, but as I sat on the CLRG myself during that period of time, the CLRG has been looking at insolvency and has been looking at very specific situations, but receivership per se has not been a headline topic of conversation.
Yeah, I'm not looking at all to catch people out in relation to putting evidence here. What I am a bit astounded, and I was going to just search that just to check to see if I was correct, because there's been numerous references on the floor of the Dáil in relation to the unregulation of receivers, and I was left clearly from that question, but it wasn't just me, there are a number of other TDs who have raised this issue as well, that this was work that was ongoing. And again, I just want to get to the point where, we can talk about this section and that section of the Act. The reality is, and let's call a spade, receivers are unregulated. Receivers in Irish law do not have to have any minimum qualifications. Receivers are running up large bills, and while they are supposed to, under Irish law, have a duty of care to the borrower, the reality is for the borrower to enforce that or to secure that duty, it requires them to go through a very legalistic process, which they're usually not in a position to do, given that a receiver has been appointed in relation to their premises. And some of this isn't about the validity of the appointment of the receiver, it's about the actions of the receiver. And then let me again say that I'm not saying that every receiver out there is involved in actions that aren't appropriate. So my focus here is whatever has happened in the past, whatever receivers have done in the past, of course there should be accountability, but how do we, as in Finance Committee, move forward? How do we, is there any hope here? That, because I thought there was hope that this has been discussed at the Company Law Review Group for the last 2 years, and maybe we would have come up with something. I thought it was just dragging its feet. But is there going to be any changes to the law outside of what is outside of that report, which we're now waiting on, and we've had an update in June that it was imminent. Now we have an update again that is imminent in relation to protecting the rights of tenants where a receiver has been appointed. In relation to the other issues that have raised, i.e. the fees issue, i.e. The appointment of receivers and not the appointment but the minimum qualifications that a receiver should have, and the third point is in relation to the regulation of those same receivers. And falling back on an issue saying they're usually accountants and they're regulated by their own body is not good enough. Absolutely not good enough. That's like saying that private security firms, well, they're usually somebody else and they're regulated. That just doesn't work. Like, we have very strong, Mr. McKenna, we have very strong legislation in relation to the regulation of security firms. You can't change a lock now without being registered as an appropriate person to do that. And maybe there might be a bit of overreach there. I'm not sure that these receivers that are walking into properties and changing the locks are actually registered with the PSA. Like, there is more, if I wanted to change a lock on my front door, I would have to go through a very stringent process in terms of the qualifications that that person has to meet. They would have to pay a fee to be registered. They would have to meet certain criteria. They would have to be obviously Garda vetted and all of the rest. But yet, if I was an institution that somebody owed me a few pound to, I could appoint any Tom, Dick or Harry to go in and take over that premise and run it on my behalf, supposedly with the interest of the borrower. And that's the problem here. The problem is we've no regulation, we've no minimum standards, and we've no ability for somebody who believes that they are being wronged where a receiver is appointed, unless they have to go to the courts. We have no authority or no body where they can complain to.
Yeah, I mean, just to say, look, the issue of receivers and residential tenancies is being and has been dealt with, and the issue of security persons who may be working with receivers is being dealt with, and I think I'm assuming that the
just
committee
when you say it has been dealt with, just not move on from that there. So let me give you an example. A receiver appointed in the dead of night goes in and changes the locks of a premise. The premise is a public house, somewhere in this state. The individual who was operating the public house was renting the premise from a landlord, and who continued to meet his or her payments on a monthly payment. His contract is fine and was secure. Yet that individual in that business is completely locked out of the property. All their investments, all their life savings that they've thrown into that is gone, because the place was closed down overnight. They have no access to it. You have whatever firm, which are usually a reputable firm, let's be honest about it, they are usually a group of accountants, but whoever, it's not the accountants that are out, changing the locks. It's not the accountants that are sitting in, in some cases playing cards and whatnot. It's not them that's in. There is another group of people that are employed who are doing this, and they have no access to the building. That company, along with job losses, has happened as a result of that receivership. So when you say that this issue in terms of tenants' rights are being protected, what changes have happened or will happen to ensure that people who have a contract, who are abiding with the contract with the landlord, whose landlord's premises goes into receivership, that their business will not be disrupted as a result of that?
I mean, again, we're back to the issue of that piece between regulation of receivers or statutory provisions dealing with receivers in companies, or I mean, we're into the area now of small, medium-sized businesses which are not corporate entities.
Yeah.
So, I mean, all the receiver in those instances can do, presumably, is to go in and carry out whatever duty is necessary for them to carry out in order to realise the value of the asset for the original mortgagee, the bank.
But
if that involves changing locks, well then, they're
the only ones that can do it. Yeah. Because if you're in a public house, if you, Mr. McKenna, are running a public house down in Kilkenny, you're the licensee. If Mr. Carroll appoints me as the receiver, I can't go in and run that public house. I have no licence to trade. The receiver is closing despite that's, and so the question I have is, what are the protections? Is there any protection? I'm kind of a wee bit at a loss here, because I came in here thinking the questions here were about how long are we going to have to wait to get more regulation? How do we get, make sure that these are regulated, make sure that there's minimum qualifications? I'm now finding out that there isn't any plan for that.
Do you want to comment on the
I'm
duties
finished
of the receiver?
on that.
Well, I can only speak for what's in the 1881 Act and the 2009 Act.
Yeah.
So this is So it's in both of those situations. So the receiver there is, as you say, appointed by the lender, but is the agent of the borrower. And the duty of the receiver, the general duty, is to secure the property and to act for the lender in terms of servicing the loan. There are certain obligations when it comes to acting fairly in the interests of the borrower. And you mentioned what appeared to be a fire sale, which would appear to be contrary to the law, because the legal obligation set out in legislation is to obtain the best price reasonably obtainable for the property. In other words, to act fairly in the interests of the borrower, not just of the lender. And that is, as I mentioned earlier, that can lead to the tension where you have tenants in a situation, because if it's residential property, for instance, you won't maximise the sale price of the property unless there's vacant possession. And that's where you come into a conflict, potentially come into a conflict between the interests of the borrower on the one hand, receiver has duties towards the borrower, and towards the lender on the other hand. And the missing part of that jigsaw at the moment is rights towards tenants who may be caught in the crossfire between a mortgagor, the borrower, who wants to obviously maximise the sale price to reduce debt, and the obligation on the receiver to service the loan on the other hand.
Chairman, sorry, I mean, as I said a while back, like, you know, we would go away and look at this following the discussion with the committee, and we're aware from other discourse that, you know, there are concerns in these areas, and if there are gaps, it's well within the competence, and as I said, we have worked successfully with our colleagues in other departments on a number of aspects related to this. We will take this away and we'll go and look at that general issue, and if there are substantial gaps that need to be addressed, well then we will come up with a strategy for dealing with that. But bearing in mind that there are the other two pieces of work, as I said, going on, one in relation to protection of residential tenancies and the other in relation to the security personnel who may be changing the locks or opening the door, but certainly, I've kind of listened carefully to what's been said here, and we will take this away and have a good look at it. And
yeah, look, I appreciate what you've said there at the end, and I think that a consultation by the department, I think you will have a lot of evidence to suggest that there is huge gaps here, and that there needs to be tighter regulation and an easier pathway for people to fulfil their rights when they feel that their rights under law, under whether it's the 1880 Act or the 2009 Act. You know, if it's a financial institution, we don't force everybody to go to the High Court. We have the Financial Service Ombudsman. There needs to be more stringent. So I would suggest a short, sharp consultation period, which would, I think, give a great insight into what is happening on the ground.
And you can see from what's been said here today that this is not one department alone that has this. It goes across a number of departments, and but that's manageable.
Do you want to answer about the Oireachtas scheme?
Yes, I can do that, Deputy. We have been running the Oireachtas scheme together with the Department of Employment and Social Affairs since July 2016. We're just finalising a report on the outcomes after 2 years, which will go to government shortly. So the data I'm going to give you is a little bit of a foretaste of that. We hope that the report, once it's gone to government, will be published very quickly. What's maybe of most interest from the point of view of your question, you were asking about the impact on the mortgage arrears problem. The Oireachtas scheme is targeted particularly at people who are in the worst mortgage arrears, people who are at immediate risk of repossession on their homes, and that would be the cohort who are in arrears equivalent to 2 years repayments or over, the 720 days category as the central bank has it. As Mr McKenna was saying, that category has been dropping, but it's the slowest to reduce, and this is, the hard coalface really in relation to addressing the mortgage arrears problem. It peaked at the end of June 2015. It's gone down at this stage very considerably, and the figure at the end of June this year on the central bank figures was 28,000 household accounts. That's probably equivalent to about 25,000 homes, because the central bank counts mortgage accounts, which includes top-ups and second mortgages and so on. But if we take it that there's 25,000 households there that are at serious risk of repossession, we have 10,000 households already in receipt of financial advice and help under the Awalia programme. So that is a significant impact.
Sorry to interrupt you. The Awalia programme, what is the extent of the financial help that's given? Just give me the figure.
Yep. What's provided is the person is given a triage under Awalia, which is implemented by MABS in consultation with the Insolvency Service. Most people will be offered a consultation with a personal insolvency practitioner. If they don't wish to look at personal insolvency, they get help from a mortgage debt advisor in MABS. So there are two alternative streams of mortgage advice. The borrower is not given money. What they're given is advice and help, but that advice and help goes throughout doing the analysis of their finance, giving them advice on the best solutions available, and negotiation with the borrower up to concluding an arrangement for them. So they will stay with a PIP or with a DMA until there is an arrangement in place for them.
So how much do they get paid?
The DMAs aren't paid anything because they are contracted to work with MABS, so they're public employees.
What money changes hands in terms of fees for these people? Is it open-ended, what the borrower can avail of? Or is it limited?
Yes. No, it's not limited, Deputy. The way we've structured it is to try and get best value for the taxpayer while making sure that the borrower stays helped until there is a solution in place for them as far as possible.
Have you no idea of the money it costs?
Yes, I can tell you that exactly, Deputy. There are two streams, right? So if you're with a DMA with MABS, there is no money, no fees paid to the DMA. They are paid salaries under contract with the MABS body that they're working with. If you're directed to a PIP, what we negotiated with PIPs is that under Awalia, they will provide a basic package of advice and assistance which follows statutory requirements laid down under the Personal Insolvency Act. For doing that, they are paid €500 plus VAT, which would be a total of €625 cost to the taxpayer. They are not paid anything else, but they are expected to continue assisting that borrower until there is a solution in place for them. The ISI is the regulator for PIPs. We are tracking and following up very carefully what is happening to borrowers who get financial advice under Awalia, and the indications are that they are staying helped in the process until there's a solution in place for them. We have 30% of all the households who have been receiving financial advice from a PIP have already got a solution in place. 95% of those solutions are keeping them in their homes. 50% of them are with a PIP and still in progress towards a solution. That's slower than we would like, but it's natural because these are the people in the worst arrears. It takes time negotiating a solution for them. A lot of them have to establish a repayment record with the lending institution before a solution can go in.
I'm working against the clock here, and I want to...
I should just mention one other financial aspect, Deputy, to be complete in the answer. The other aspect is that if a proposal is made to a lender for a personal insolvency arrangement for them and it's refused, Awalia also covers legal aid for the PIP to take the review to court for the court to check whether it should be imposed on
And
the
what's
borrower.
the cost there?
That cost's more significant because it's
That
paid
costs what?
on legal aid scales which are agreed with the legal aid board.
All right. Look, I respect all the work that you're doing, so I'll start from that point. The reason why I asked that the committee would bring in, yourselves before the committee to understand what's going on is because of the numerous stories that I have heard about receivers. So I'm giving you this information out of my discussions with borrowers and all the rest of it. And the first thing that I wanted to absolutely clear was the fact that receivers are they're not accountable and they're not regulated. And I think, Mr. McKenna, if I'm right, you said receivers are not accountable and they're not regulated. Now forget their background, maybe they're accountants or whatever. So receivers are appointed, and when they're appointed, they take total control. In fact, a number of receivers, I'm not saying all of them, a number of receivers, the ones that I have experienced, act like thugs and bullies. In Kilkenny, they set about notifying almost a complete housing estate that the receiver was now there, taking over the property, and they set out their case. No prior lead up to this, just notified everybody. In fact, they didn't even own the houses. The houses belonged to Kilkenny County Council. But yet, for the period of time that the tenant had got these letters, they were terrified. Because they saw these receivers, or those people acting for receivers, literally breaking down front doors and changing locks on vacant houses, and bullying people in their family homes. Now that's just one example. I'll give you the example directly in relation to a case here in Dublin, where the receiver was Grant Thornton. I'm naming them because it was in the public domain, so there's no issue around that. And it was in the public domain because I went to them and tried to meet with them to discuss a case that they were pursuing. And they then did to me what they do to an awful lot of other people who tried to help. They got their solicitors to write to me. They spoke to me about the separation of powers, and they accused me of interfering and so on. That's the type of activity that's going on all over the country. Deputy Doherty gave you an example which is not unusual. Not unusual. And social media give us reports of the various attempted evictions and so on that have gone on, and the activities of these people when they visit homes. It's shocking. And I always believed that there was some form of regulation there, but there isn't. So I'm putting it to you that receivers are often appointed with no other purpose in mind but to strong-arm the borrower and take possession. And once they take possession, the borrower can't even get an account of the rents that they collect. The borrower is totally ignored, and the asset is often run down to the extent that is far less value in it, in the context of the sale, than what would have been the case had the borrower sold it. And this is what's going on. The rip-off in professional fees relative to this activity is criminal. And I note from Deputy Doherty the quote from the Master of the High Court, where unaccountable receivership is licence for theft. That's the experience of people. It's not, my view is not an extreme view. It's based on fact. And there seems to be no effort being made to curtail the activities of these receivers. Now, some of them may very well be accountants, but I doubt very much if they're all accountants, if they are all qualified to do this job that they're doing. So we have to intervene. We absolutely have to intervene. There's no question about that. And I'm disappointed that, given all of the experiences that deputies have had, that there isn't a greater effort made to ensure that these people are accountable. Now, the last comment I'll make on it, and I'd like your response to some of what I've said, is that when they reach an impasse, or when a difficult point in negotiations between the borrower and maybe it's a vulture fund or maybe it's a bank, whatever, is reached, the threat then is that a receiver will be appointed immediately. And the intention there is to force the hand of the borrower to come up with the money, or they're going to lose everything. That's what the threat is. So it's another method used to squeeze money out of the already squeezed borrower. It's simply corrupt, the whole thing. And I believe that there is now a time when, this is now the time, when, not referring it to another group to deal with it, it's a time when I think you have to take immediate action to put the small things in place to prevent some of these big things from happening, and then deal with the overall picture later on. But it's outrageous that they're not either accountable or regulated. And I think that there is clearly opportunities being taken by these individuals to collect large sums of money from rents, to sell properties and push up the price because the borrower is in trouble. And, I wonder, is the receivership used also to clear title through courts so they can actually sell properties and after the sale is over, if the title is wrong or if there's something odd about it, that they can clean it and off it goes. There is serious misgivings about all of this that I think the departments, various departments, need to address without delay. And I'd like to know what sort of immediate response we're going to have to the issues that we have raised today at this meeting. And please don't tell me we're going to have a review group, because the receivers will jump with joy when they hear that.
Thanks, Chairman. Just to go back to the very start there, in terms of me saying receivers are not accountable, not regulated, just to confirm, receivers, there is no instrument law generally regulating receivers. That's not to say, as I said earlier, that they're not regulated as professionals if they are members of professional bodies by their own professionals.
Sorry, can I just stop you there, Mr. McKenna, because this is the nub of the thing. If you are a receiver and you are an accountant, it is looked upon that your accountancy regulator doesn't look at your work as a receiver. It may be the case that you're putting forward that, well, if you're regulated as an accountant, you must be an okay kind of person. I question that too, because we had the accountants during the bank collapse, and they weren't okay kind of people. They certainly got their figures wrong, to say that, just to put it at its mildest. So I'm asking you, will you regulate separately receivers? Because they're going around the country like cowboys doing the work.
So, I was just going back to make that point, but I suppose where we're coming from in that regard also is that a number of professional regulatory bodies and professional regulators have clauses in their regulatory system about actions bringing the profession into disrepute and things like that. So it's not beyond the bounds of possibility that those kind of routes can be used. But having said that, we take the point. But the other thing about most of what we're hearing, including today, about receivers has to do with the issue of rights of tenants in a receivership. and unacceptable behaviour by receivers and/or receiver assistants. And what I was trying to point out earlier was that those two areas are areas that are already being looked at and looked at very carefully, and in the case of tenants are near a conclusion, and that I think is something which the committee might want to look at when that piece is produced by Department of Housing, because I think it will be quite an effective piece.
Mr McKenna, I'm just saying to you again, I'm sorry for interrupting you as we go along on this, but just to take each point as you make it, I don't want them to just look at it. I want actually somebody.
No, I understand in that instance there will be a report with recommendations.
Yeah. To bring in legislation. Relying on regulators, for example, the regulatory body for accountants. Well, when did you last see an accountant being held to account by the regulator? Was there any of the big four, any of the ones that are regulated, held to account in relation to the banking crisis?
Well, I don't have that information with me.
No, I can give it to you. There was none. So I'm asking you, because this is a live issue, to take the issue of receivers and to deal with them in some way, to bring in legislation that would sort this out as quickly as possible.
Yeah, well, as I have already made the point as well, that we will take this away and we will look at it between the departments that are concerned. It's a complex issue that cuts across a number of different departments. That's not to say that we can't solve it and that we won't go away and consider carefully everything that's been said today and follow up on it.
Chairman, can I just...
Sorry, you just said...
Yeah.
So just finish here. Is there any other point you wish to make, Mr McKenna?
No, Seamus Carroll already explained earlier about the obligations of receivers, both to mortgagors and mortgagees. So in terms of their obligations, in terms of price obtained, etc. So it's not straightforward to say, if you like, that they have no obligations. They do have obligations both to mortgagors and
but
mortgagees.
It's also
And in a number of cases, receivers are acting on the basis of powers which they have under mortgage contracts which have been signed by both the mortgagor and the mortgagee, and presumably contracts in which they got advice about before they signed them.
Yes, that's true, Mr McKenna. But I would point out to you that when these contracts were signed, they were signed in the hope that this was going to be, that there was going to be a successful outcome to it.
Of course.
Right? So now there isn't a successful outcome to it, and the person that signed it, the borrower, is relying on the fact that in this contract it says the receiver shall act for the borrower and the lender. Right? Never expecting a receiver to turn up, ignore obligations, and then beat the lard out of the borrower, or completely ignore the rights of the borrower. And that's what's going on all over the country.
Well, Chairman, just
and there's
as I
lots
said,
of evidence there. I'm not just saying it.
as I said before, in relation to the idea that somebody would be beating the lard out of somebody, I mean, that engages the criminal law, and nobody can tolerate that.
I want to address that now. You made that point, right? So the fact is, criminal law. So here you have a person beaten up by the economic crash, turning to a contract and trying to get some comfort from that contract, failing miserably because they're busy with keeping their life together, trying to keep a business together, a family together, and trying to stave off the actions of a receiver who has no interest in obligation. That person often does not have the money or indeed the physical, mental disposition to go to court to defend themselves. And they're presuming, because these people are acting in the way that they're acting, that they have the full might of law behind them. And what we're discovering here today is that they don't, and that the people that they're dealing with are not regulated. But unfortunately, as was with the case that I mentioned, that was a case that I took up, one of the many, with the same outcomes, the receiver decided that they were going to get me off the pitch, so they sent me a stiff solicitor's letter, and I was supposed to buckle at the knees at that, which I didn't. But I can imagine that the person who is defending their property and their family and trying to keep some of it together for the future, they buckle at the knees and they don't have the funds. And I'm just trying to get that message across to you, how weak the system is and how weak the individual is against the might of the lender and one of the big accountancy firms. So what they're doing is they're using their money to ensure that they get what they want, and they'll beat up anyone in the process. That's the reality. And I'm asking you just to take note of that.
Yes.
I just ask me after the meeting, and I'll give you lots of examples, like Deputy Doherty did, as to how these things function in reality. That's all I'm saying to you. I'm angry about the fact, I'm frustrated by the fact that we don't have legislation. I'm trying to get that across to you and encourage you to look as quickly as possible at the situation to bring about some form of resolution that will tilt the balance somewhat in the favour of the individual making an effort. That's all I'm saying. I'd ask you to consider that.
We will. Thank you.
That brings us to the end of this part of the session, so I want to thank you for coming along. I appreciate it, and you might let us know how you're getting along with the outcome of the meeting. Thank you very much.
Thank you, Chairman.
We'll suspend now for 10 minutes while the witnesses come in. We're dealing with item number 9, which is a sale of loans to unregulated private investment funds. I want to welcome Joe Healy, President of the Irish Farmers Association, Mr Neil MacDonald, CEO from ISME, and Mr Paddy, Financial Advisor. Now, before we begin our meeting, I wish to advise witnesses that by virtue of 17(2)(I) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. If you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that where possible you should not criticise or make charges against any persons or entity by name or in such a way as to make him or it identifiable. Members are reminded of a long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against a person outside the House or an official either by name or in such a way as to make them identifiable. I want to ask Mr Healy now for your opening statement, please.
Thank you very much, Chairman, and good morning to the members of this committee. Thank you for inviting IFA here today to discuss the sale of bank loans to private equity firms, otherwise known as vulture funds, and the impact this is having on farming community. I'm joined here today by Martin Stapleton, our IFA Farm Business Committee Chairman, and Damien MacDonald, our Director General. 10 years after the global financial crisis, the failure of banking institutes in Ireland and abroad has led to significant changes in the sale and restructuring of loans to third parties. Over the last 3 years, the effect of this restructuring and selling of loans to private equity firms, or so-called vulture funds, is having a significant impact on borrowers. Many of these sales have farm debt in their portfolio. IFA has been contacted directly by farmers in such situations, and since July 2017 we have had a dedicated debt support services team. We have approximately 150 cases active on our system, with new inquiries every week. We represent these farmers in negotiations with the aim of finding a workable resolution for all parties. Today I would like to outline the issues faced by farmers and the negotiating environment they are faced with as borrowers in financial difficulty. The agricultural portfolio in Irish banking institutes is one of the best performing portfolios given the rate at which they repay their borrowings. Central bank figures indicate that overall level of outstanding borrowings in the primary sector are falling over the last 8 years. In 2010, outstanding credit was estimated to be €5.1 billion, while in June of this year this is estimated to be at €3.6 billion, a reduction of 30%. In the wider context, agriculture as part of the SME sector represents 22% of all new lending. These figures reflect the importance of the agricultural portfolio to the wider economy, with particular significance in rural economies. Farmers generally borrow from our pillar banks. These are financial institutions which have built up long-standing relations with families over generations. These were relationships where farmers sought advice from and trusted their banks to act in their mutual best interest. On this basis, farmers borrowed money from established and reputable banks in good faith. They did so in the knowledge that they would have to repay the money, but also with the security of knowing that the bank had a restructuring unit to provide options should their business plans struggle. As already stated, in recent years these institutions have sold farm debt to third-party vulture funds. These vulture funds take a short-term debt recovery approach to the loans acquired. They are not interested in working out a long-term debt resolution with the customer. This short-term debt recovery approach through the sale of assets damages the underlying viability of family farms, as the repayment capacity of the business is not considered. As the ratio of the security value to debt level tends to be significantly higher, this issue is a particular problem for the farming sector. Regardless of the repayment capacity of the farm, the fund views these debts as having a very high recovery potential. Funds are in a position to liquidate the assets against which the loans are secured at whatever value they wish and in whatever time frame they wish in order to maximise recovery of the debt. This means that the vulture funds see it as possible to recover the full value of loans plus their costs immediately by appointing a receiver and forcing a farm sale. In many other sectors where there is significantly less security, deals are being done based on the repayment capacity of the business, and businesses are refinanced accordingly. It's IFA's policy to prevent vulture funds from killing off farm businesses that have the potential to repay their debts over time and, by doing so, return to viability. The issues outlined are not confined solely to the vulture fund engagements. With the banks who are not selling loan books, there is some potential to discuss longer-term repayment arrangements as they seek to protect reputation and also to ensure a viable farm can return to a profitable customer in the future. Farmers view banks who sell their loan books and abdicating their responsibility to see through their dealings with their customers. There is a loss of confidence in the banks among the farming community, and it's now necessary for the banks to recognise this and to provide all possible solutions to the borrower before the sale of loans. In particular, the opportunity for farmers to repay loans in line with their repayment capacity with longer-term options established, ensuring the sustainability of the business. The following are four major issues which must be addressed for current and future lending: regulation of loan owners, engagement by lenders, accountability and rebalancing in negotiations. IFA acknowledges the Consumer Protection Bill 2018 and its purpose to regulate credit agreement owners of mortgage loans and SME loans. There must be provision in the regulation of funds for enforcement by the financial regulator and oversight post-trade. This means that the financial regulator must have information on the loan owners, the number of loans they own and the profile of the borrowers. Borrowers must have the option to engage directly with the loan owners and not only through third-party agencies. The current system of employing asset managers as intermediaries is not working. Banks should be conscious that to sell loans is to crystallise a serious failure on behalf of a bank. Such action leaves an irremovable stain on the legacy of the bank. Lenders must realise that to commit to a long-term repayment plan is an enormous challenge and may lead to a generation of a particular family devoting their entire working lives to retaining the family farm. In doing so, they accept that the alternative is to sell. Quite often a partial sale is seen as a more practical solution, but we believe that each family should have the opportunity to negotiate an option. The risk of moral hazard is often quoted as being a reason for using the funds to sort our non-performing loans. We need to acknowledge that moral hazard dies when there is a partial asset sale. Loan owners must be forced to provide long-term repayment options, as demand loans are totally unsuitable for farm businesses. There must be accountability of these funds to the Minister for Finance and to the Houses of the Oireachtas. There must also be a mechanism whereby information on the actions of these funds can be made publicly available through Oireachtas scrutiny. The current secrecy around sale values leaves the door wide open for sweetheart deals at the expense of the borrower and the taxpayer. It's unforgivable that loans are being sold to foreign hedge funds for less than what could be recovered from the borrower. This leads to a loss of capital from the state, which could and should be available for investment here in future projects. Furthermore, profits from these transactions are leaving this country tax-free. A balance must be struck in supporting farmers who are in a difficult situation. In doing this, we must maintain the integrity of the wider agricultural sector, the majority of whom are paying off their debts in full, and for whom the ability to give assets as security as part of their loan application is very important. Steps must be taken by the Government to provide a greater balance in the negotiating strengths of the parties in these situations. Where the family farm is willing to agree to commit to a reasonable, credible long-term repayment plan in accordance with the repayment capacity of their farm, there should be the following 4 or 5 points. Number 1, no forced sale of farming assets which undermines the viability of the family farm and where the farmer has meaningfully engaged to find a workable solution. Number 2, a full and final agreement reached between the borrower and the loan owner prior to the disposal of any assets. No forced collection of debt that is not yet due. Assets must be sold for their full market value and with proper advertising, and no interest or penalty accumulated on the outstanding debt where delays occur in arriving at a decision. Insolvency legislation should be adapted so that farmland is treated similar to a principal private dwelling house. In effect, a farm is both a home and a means to make a living, as is provided for in insolvency under the term tools for the trade. This option would give court protection to borrowers and ensure that a fair repayment plan is implemented, giving security to both the borrower and the lender. Interest should be based on the cost of funds for the loan owner rather than the money owed. A fixed minimum percentage of total debt plus a margin on costs of funds paid annually should offer protection against a repossession order. Chairman, in conclusion, the sale of loan books is not a necessary or suitable way for banks to deal with debt secured on farmland. Greater protection is required to protect borrowers, and better engagement by banks to achieve a sustainable solution is necessary. The Government has recognised that farmland and business assets should be treated differently than other asset classes, as has been recognised most recently in the proposed new Fair Deal scheme. It is vital that similar recognition is applied here. Thank you, Chairman.
Thank you very much, Mr. Healy. Mr. MacDonald.
Chairman, ISME thanks the committee for their invitation to address the issue of debt transfer to so-called vulture funds today. I was to have been accompanied here today by a member company which is going through a debt restructure, but it was made very clear to them that the offer being negotiated currently would not be honoured if the company appeared before you. ISME members are not ignorant of the fact that some borrowers are unable to repay their debts and that lenders must have recourse to debt resolution mechanisms. We are also aware that many of the funds to which SME debt is sold are willing to come to negotiated settlement arrangements with borrowers. What is incomprehensible to many SMEs, however, is that these banks seem incapable of coming to what are, in many cases, quite straightforward arrangements without having recourse to selling debt to third parties. These debt sales are cost additive in terms of professional and legal fees. They are also highly complex and impose on borrowers a stress and a workload they would never normally encounter as part of normal business lending. This, on top of the fact that debt sales are normally confined to distressed borrowers, places a huge strain on that customer. These sales typically take place at a substantial discount to the book value of the debt, and one wonders why those taking the business decision to sell that debt cannot come to an agreement with their customers at or close to the written down value at which they are selling their debt. Indeed, we know of one member company which has recently been informed that their overdraft of some €20,000 has been sold by a pillar bank to a fund. The most common complaints we encounter about the sale of debt to funds concern the unreasonable exercise of personal guarantees. We understand that lenders need some degree of security for the funds they extend, and personal guarantees can form part of that. However, personal guarantees are never extended by borrowers on the basis that they can be suddenly or peremptorily exercised. Borrowers view them as a last resort, not something to be used to exert heavy short-term leverage upon them. Some institutions maintain personal guarantees after the debt raised against them has been fully discharged. This is immoral. Settlement agreements also typically involve confidentiality and gagging clauses. Below are provided the testimonies of two ISME companies involved in debt and sale and restructure, one of which is promised some debt forgiveness, the other of which has repaid 100% of its debt sold. Chairman, I don't propose to read their testimonies, they're on the record, but I will say that the arrangement that involved debt forgiveness did require the sale of a family home, and in the other case the business was liquidated at the cost of redundancies for all the employees working therein. And lastly, I would make the point to the members of the committee that the ISME bank survey will be published later on today. We now regularly ask our members how many of them have had their debt sold, and the figure that will appear in the press release today says that 10% of our members have had their debt sold by their lender to a third party. Thank you,
Thanks
Chair.
very much, Mr MacDonald. Without going into any detail, is that a vulture fund or a bank that you mentioned in your second paragraph, where you say a member company is going through a debt restructuring?
It was the receiver that informed our member's accountant that if she appeared today, those arrangements were not guaranteed.
But is that a bank or is it a vulture fund?
It is a receiver on behalf of a fund.
Okay.
Yeah.
Thank you very much, Mr MacDonald. Mr Cassan, you're very welcome again to this committee.
Morning, Chair, members of the Finance Committee, fellow speakers. You asked me to come along today to reflect on my experience of the customers that I know that are affected with the ongoing sale of, I suppose, mortgages in the main, notwithstanding what was said previously. They're collectively known as domestic loans, but they're for homes and investments. I know it spreads across, as we've heard, to other businesses and other areas. The connectivity, because I listened to the previous discussion with regard to receivers, is hugely connected to this issue. It covers, for me, homeowners and residential units. Discussion around this matter is quite complicated. Words used like morals and hazards and NPLs and appropriate percentages, etc., are used a lot of the time to confuse matters. There's no doubt that the percentage of loans in arrears in this country is higher than it is throughout Europe. The question is why. Why do Irish people have a greater level of arrears on their loans than other countries throughout Europe? And is it all the fault of the customers? I suggest no in most cases. There are a number of reasons why the arrears are so high. Examples of some of those reasons are the price the property was bought at and the levels of lending to facilitate that purchase available at the time. Interest rate levels for loans in Ireland. Some of these loans are currently at 6% or greater. The economic circumstances that befell the country for the past 9 years certainly contributes. The treatment by our government of the residential lending market, non-principal private residence tax, reduction in interest relief as examples. Decreasing values and depressed values versus the loan size came into play. Decreasing rental yields and concurrently at that time a decreasing rental market. The property culture and the atmosphere that existed at the purchase time, it was the topic for the country. Customers' own economics, income and employment position. All interested parties contributed here. For example, stamp duty levels for rental purchases seems to be forgotten, where what these amateur investors contributed to the economy at the time. But the question that should be defined is what, when you take the issues as a whole into account, is a non-performing loan? Is a non-performing loan happening because of external factors, or is it the customer's own fault? That is the question. Look at the position at purchase time and the position a few years later. They're at polar opposites to what were the intentions for the majority of customers and indeed the lenders. All were caught in the tsunami of the crash and panic set in, but responsibility was deflected. Bank solutions initially was interest-only extensions, and then further extensions, and then a sudden shift to pay in full, sell, or we will. You must pay the balance of the loan as well, by the way. An example of shortening the term which interest-only would have achieved would be if you borrow €1 million over 20 years at 0%, it's 50,000 per year. That same million repayable over 10 years is 100,000 a year. The short-sighted view of interest-only as a solution is staggering. Each interest-only period was actually increasing the difficulty for customers to be ever able to recommence repaying capital and interest, but it was presented as a solution. It actually shortened the term of the loan. I cannot understand the reluctance to the most obvious solution, which was term extension and interest reduction, to see how it all played out. In fact, it is arguable that there is no risk to a bank for many of these loans to remain on an interest-only basis for the full term of the loan. All would then be classed as performing loans, but with debt levels not reducing. This assumes that the interest repayment would be made in full. I cannot understand, for example, how not one lender in the 12 that I've come across with the tracker issue didn't take the following view. You have borrowed a lot of money and we promise and we propose to extend the term on your loan by 10 years, take 1% off the interest rate, and let's see how all this will work out. Not one lender saw this as a solution to any of its customers. All, including our government, fed from the trough of property in the tiger years, but when the feed started running out, namely credit, panic set in and the world changed as it did in Ireland. But properly thought through solutions were as scarce as the credit lines. Solutions that took a long-term view were non-existent in my view and are still not considered in most rental cases. I cannot understand how, for example, a domestic NAMA bank was not established, and indeed I would argue that there could still be room for some with proper establishment. We are today as a country exporting the profit from the recovery to entities that have done very little but wait in the wings of this country until meltdown and have come in and picked up the assets at the bottom of the market. This is an enormous industry which ironically self-creates itself as a market every so many years. Gordon Brown told the UN in 2002 when he was describing vulture funds who were making profit from purchasing distressed debts of a country at a reduced price to then make a profit from suing that same country as morally outrageous. The same is occurring here in some instances. I know, for example, that if the value of a home is greater than the loan, full repayment by the sale of the home is the only option given in some cases. What is paid by these funds for the loans is a great mystery here that no one seems to know. However, if you review the websites of the main players in the Irish market, the answers are clear. They are queuing up to come here. It is a very, very profitable business. Is there not a way to control this as a country, given the fallout that will occur in the domestic market in particular, and I pay particular reference to the farm issues which would be connected to homes as well, and the current property crisis that exists? The need for property is clear across the whole country, but that need was always there. It appears now that it will in the future become a market, especially in the rental area, where only the biggest players are involved in the rental of those properties. It has been stated before that the whole area of moral hazard revolving around these issues and the repayment of debt, but that morality must extend to all here. Are there other options open to us as a state? If any of these affected customers or tenants get moved out, who picks up that tab? The discount on the loan must be priced to encourage the vulture to buy, but it is certainly the case in Ireland because it's a bidding war that ensues. There must be very little, if any, risk to the vultures. So why is the risk so much greater to the bank for holding these loans? ECB directed a lot of matters to this country early on in this debacle, and it seems like it is involved again, or is that what is being put out by the lenders? ECB says we must do it, reducing our NPLs, so selling billions of loans to eager vultures is the only solution. Why, for example, can the government not create the vehicle and benefit from the upturn that the vultures expect to receive? There is, after all, a bidding queue to purchase these loans. Why must be the question. Additionally, what of the tax treatments and benefits each of the vultures and the lenders receive with add-backs which will benefit the banks for many years to come, as has been confirmed? The responsibilities lie across many desks here in regards to the issue, and some are certainly running from those responsibilities, including, it has to be said, some customers, but I do not believe the figures are as high as presented by the banks. To quote one of these vulture funds from its own website as an example, we believe less efficient markets exist in which dispassionate application of skill and effort should pay off for our clients, and it is only in such markets that we will invest. An inefficient market is described as one in which an asset's market value does not always accurately reflect its true market value. That's the game for these funds. The fallout affects not only customers but tenants, the government, lenders, revenue, and it can collectively be called as a big contributor to the housing crisis. There is certainly room for some more thought that should be applied here, and in most cases the short-term solutions actually present longer-term problems. Taking a longer-term view needs to occur, similar to the original granting and indeed the intention of the loan in the first place. Just because an injury occurred doesn't mean you drop the idea. Some thoughts that I thought I should raise for consideration. In 2010 there was a shortage of houses, and that was missed by most, including the Department of Finance. Non-performing loans became the next subject matter of the ECB. Does this drive the sale book of the loan book? Interest only is not listed as a long-term solution. Why? Repossession is hinted at, and it is a threat across all spheres of lending. Incentive to reduce the non-performing loans by disposal is being put forward as the only solution. Banks are forced to take provisions at the lowest part of their market, but the add-backs is not considered. What is a non-performing loan? More importantly, who defines it? It has never been properly answered. What is the tax treatment for the private fund, the investment funds on the profits gained? Why is the market so buoyant in Ireland for vultures? What drives that market? Be certain vultures are in this for profit, and predominantly it's short-term. Is it the same in Spain, Portugal and Italy? Warehousing loans, the questions that are not being asked, what happens at the end? The 3-year reviews, most don't know what will happen. If there was more certainty in the answers, it might solve some of the mystery surrounding vultures. What protections are in place? Are these certain for investors as well as homeowners? And I bring it to finish, which I hadn't in the two particular examples, given similarities. I know of 2 homeowners, as an example, who are currently now with vulture funds. Both were performing loans, both were never in arrears, both were PTSB, who now want to extend those homes and have gone to the vultures and said, we're not a bank, we can do nothing. They're both tracker mortgages. Your only option is to move your loan and pay 3 times what you were paying. Thank you.
Thanks very much, Mr. Sam. Deputy McGrath.
Thanks very much, Chair. I'd like to thank all of our witnesses for the opening statements. If I can start either on the farm or business end, I don't mind which one of you takes this question. But can you just characterise for us what your members report in terms of what these funds are like to deal with and the prospect of getting a deal? We sometimes hear from supporters and advocates of these funds that they're more likely to do a deal. That would be put forward normally in relation to mortgages. But can you just give us a sense, what are they like to deal with, and are deals being done? And if so, what kind of deals? And are long-term restructures being done in relation to whether it be farm debt or SME debt? Are they entering into long-term restructures that clearly go beyond their investment horizon in Ireland, which is a short number of years?
Okay. I'll take that, Deputy. So, when a farmer, and I presume it's the same for any other borrower that has their loan sold, they get what we call a hello letter from the fund. An engagement then is directed towards the asset management company that fund employs to do their business for them. More often than not, the instruction the asset management company has got is that par recovery of debt is the only option that's available. So instead of, and I think that the asset management company was put in place as a regulated entity for engagement, but instead of that system working to the benefit of the borrower, it works to the benefit of the loan owner.
This is the credit servicing firm now, the intermediary you're talking about.
The intermediary, yeah. So it works against the loan owner, and it's a barrier to negotiation.
So how does it work in practice? I mean, all of the borrower's contact is with the agent?
So we will contact, but the instruction that they will, or that most often the correspondence they will come back to us is, we have been instructed by our client, which is the fund, that we must recover all the debt. And their aim is to recover that debt as fast as possible. Letters will be sent, which will lead to the progress of how it develops. Usually the appointment of a receiver, then the receiver will take over the communication and will work towards selling the asset. So there's no possibility that I can see of the funds being interested in long-term arrangements.
And who are you negotiating with then?
We try to negotiate with the asset management company, whatever it is. Sometimes we get the opportunity to negotiate directly with the fund, or not so much negotiate as to consult might be a better way to do it.
And do you get to meet with the fund directly in some cases?
No, we've met with the fund on an overall view, but not with them on cases, individual cases.
Okay, so at IFA level, you've had engagement with them about their strategy and
exactly.
So on.
And you know, what we have been told by the fund is they have their fiduciary duty to recover as much as they possibly can for their investors.
So when you get a meeting in relation to an individual farmer's case, it's with the agent, the credit servicing agent?
Generally, we have come to the conclusion that meetings are not worth the time that you invest in them. So it's a real dysfunctional system, Deputy, that we don't get real engagement on it. It's the asset manager will tell us we need par recovery. Receiver will then eventually be appointed. We can do an engagement with the receiver quite often. Again, the attitude and the tactics that the receivers employ is quite different, depending on it's as different as the number of receivers that's there. But it's always focused on the maximum possible recovery in the shortest possible time.
And in your view and your experience, who's making the final decision? If you put forward a proposal on behalf of the farmer,
the fund
is making the decision, but you can't have any direct engagement with them on an individual case.
I think the law prevents that.
Yeah.
I think that's the way it's set up, that our negotiations must go through the asset manager or as the receiver.
Okay, and it's your experience they're not making any decision. They just say we'll bring your proposal to the fund, and then they'll come back with. Their
job is to collect information for the fund and to communicate back to the borrower about
and
timelines involved and when a sale will take place.
And what type of restructures, if any, are you seeing get fully approved through the system? And the same for Mr. MacDonald, like where that don't involve repossession and the loss of the asset.
In general,
are you seeing funds enter into loan restructures with farmers that maybe extend the debt or park some of it or reduce the interest rate, or is that happening?
No, I think the garden variety deal comes along with there will be an asset sale which will reduce the value of so the asset sale will take place, and the proceeds from that will reduce the debt to such a state that then a farmer can sustainably borrow the rest of the debt from Pillar Bank.
But typically it involves an asset sale
Yes, but never or almost never a write-down on the debt.
Yeah, Mr. MacDonald, your experience of your member firms of dealing with funds and the prospect of getting a deal which involves the restructure of the debt over a period of years into the future.
That is quite opaque. We're not actually in the business of gathering a lot of information on that. However, what I will say, and I tried to cover off the two bases in the case studies that were there, this is, and both my colleagues either side have referred to the degree of opacity in the process. So a lender sells a loan for 40% of face value. The fund has an asset worth 60% of the original borrowings. What isn't evident to the borrower, who is dealing with the receiver on behalf of a fund, is how much are they expecting to receive, how many cents on the euro are they expecting to receive, and what is the bonusing arrangement that is working between those two parties, because effectively there is a negotiation taking place between those two, and that isn't always evident. And this arose in the earlier session. I was listening in to the chairman's interaction earlier on. This is as much an interaction with the receiver, who can force sales at a pace which is totally unrealistic, especially in a market where assets are depressed in value. Now the dynamic is reversed. Asset prices are going up, so there's a concern among some of our members that where there was forbearance before, the forbearance was tactical, and it was because the asset values were depressed, but now because those asset values are at or above par.
But in cases where there isn't a receiver in the picture, so again,
it really does depend on it. The feedback I get suggests that the greater the discount that was applied to the sale of the original debt, the faster the fund wants to move. But I couldn't give that to you as a hard and fast rule. Okay.
You mentioned the issue of confidentiality and gagging clauses in settlement agreements. So what's the experience there?
It's made quite clear that, and they are required to sign their way all through this. This deal is private and confidential and may not be referred to again. You might say that once the deal is done, well, what recourse is there? Well, actually, the fact that most of these borrowers are dealing with the pillar banks, there really is a genuine fear of retribution. I've experienced that over the last number of years, even where the behaviour of a pillar bank was quite disgraceful, and the member went to the media. They did so on an anonymous basis. They would not have the name of their company or their directors put in the media.
And the use of these clauses would apply whether you're dealing with a bank or with a fund. I mean, they're quite common. I mean, the first loans to be sold would have been, what, 4 or 5 years ago? How much experience is there now across your organisations of dealing with this issue? And I know it's building and growing all the time as more and more loans are being sold, but there must be several years of experience now.
Yeah, as we said in the presentation, Deputy, we have 150, give or take, a few active cases now. So it gets more and more frustrating for us in dealing with the funds and their absolute desire to recover the money as fastest in the fastest possible time frame. We had a tradition in this country, or a past or a history, where when borrowers got into trouble, and I'm speaking specifically about farm borrowers, the means that was done was there was some sort of an asset sale, generally non-core assets, and then a write-down to a level that would allow the bank to put in place a long-term sustainable debt. The write-down and the sustainable debt, working together, share the pain between the borrower and the lender. And eventually, that borrower, through hard work and dedication and paying back their money, got the opportunity to get their business back to viability and back operating again, allowed the family to maintain ownership and continue to work that farm. Okay. That has changed completely. Yeah. And I want to make this point, Deputy. That has changed completely. The way it works. Once the loan are sold, that option is no longer on the table. But it's also impacting on the banks, or the incentive is there for the bank to go and do the deal, because they now have the option of selling on the loan and as a way of getting the NPL off their books.
Mr. Kassan, in relation to mortgages, so PDHs, so owner-occupier mortgages, your experience of the type of arrangements that the funds are willing to do. So will they do the long-term mortgage restructures? So I'm talking about the Lone Star, now Cerberus, Oak Tree, Tanager. Will they do the basic restructures like extended term, interest only, which you refer to, split mortgages? What's your experience? So again, they don't have a long-term investment horizon, but are they prepared to enter into new restructures?
Well, I think the first thing they're prepared to do is enter the market. And the one difficulty they have with a domestic mortgage is the term of the original loan is what will dictate the term of how long it can run. So if some arrangement can be put in place, it'll relate to the original loan. But as I mentioned in the opening lines, the difficulty with a lot of the homeowners that are now being sold is they might have had a forbearance arrangement directly with the bank heretofore, which would have been interest only or part capital and some interest, and they're losing dramatic time in that. But now that it has been shoved out to the Vulture Fund, the original term of the contract stands, so all this time is lost. So as I gave a clear example of a 0% loan at €1 million, it's 50 over 20 and it's 100 over 10. That's what's causing a huge issue here. But also concurrent with that is the increasing values in the properties. So the banks can now, so a good loan is being sold at approximately 50%. In other words, the better of the cases. It's below that for the worst of the cases. That's a generalisation because I don't know for certain. I know David Hall has done a huge amount of positive work here, and I suppose what the collective group are saying here is, can we not start to think outside the 9 dots here? There's a reason they're coming into the market, and it's profit. It is. I'm looking at the websites of the research here. I'm looking at Goldman Sachs, Goldman Vulture Funds collect 456 million in distressed Irish loans last year alone. So I mean, the facts are there. They're not here for any great benefit of the customer. The difficulty in all of it, Deputy, is the don't know factors when you introduce it as a home or a farm, and I would connect farms to this because the shame and embarrassment and don't know factors of that going forward is not being captured at all. And a lot of the time, I hear a lot of people talking about the moral hazard of people not paying their debts. I haven't come across it. I don't know where all these strategic defaulters are. Because first of all, I'd raise the question, who would strategically default on their home? I mean, it'd be the most stupid thing you could do. There are absolutely people that are in difficulty that will have to sell home, but that should be a finite percentage that a state should be able to carry. But given the proposals that are there at the moment of the thousands and thousands of homeowners that are going to have repossessions, they'll no state carry it, and yet they'll fly off with the profits from it because they're just selling the property.
Yeah. Final question. You asked the question yourself, warehousing loans, what happens at the end? And I want to put that question back to you because there's about €1.5 billion of warehoused mortgage debt under split mortgages. The average is in the region of €50,000. So somebody enters into a restructure, they pay the active part of the mortgage, but 10 or 15 years down the line, when the mortgage comes to an end, there's a debt sitting there. And this is untested because these agreements have not come to an end yet, but it's about €1.5 billion of mortgage debt parked. What happens to it in your view? And do you think, with the uncertainty that is there as to what happens, is it a good model, split mortgages and warehousing debt?
Well, you see, the circle isn't drawn in full. First of all, now the banks are taking the view that here are the distressed loans, let's move them out to vultures. As night follows day, the next area that will be looked at is the warehouse loans, because they are now the next non-performing loan, and that will get moved out. The reason I'm raising the question is to create the question and to create the possibility that answers might come. Nobody is asking what happens with warehouse loans at the end. Are you going to have all these 70-year-olds out of their homes because they have to sell? Now, some will absolutely take the view that they should trade down and move to a smaller house and so forth, but nobody's asking the question. I would raise it even more serious. Most of these arrangements that were put in place have 3-year reviews on them, which are now currently in play to the Vulture Fund. And they're absolutely back in with their contracts and back in with the arrangement. You were told it was going to be reviewed in 3 years with a pillar bank. It's now being reviewed with the Vulture, and that's their opportunity to come in to take the short-term view that they have. So you're absolutely right. I do not know today, as a financial advisor, what will happen with warehousing. I'm being told in the surrounds it's written off already, so why not do it? If the provisioning has already been taken that the taxpayer has picked the hit for. I mean, the other aspect that isn't looked at this at all is the rental market and the contributory effect of the sale of vulture funds, the amount of properties that are empty because receivers are appointed. I have been at meetings with clients and the bank can't tell me who has the keys. The client knows they gave them back to the bank and nobody knows who has the keys and the property is empty. It's astonishing stuff.
Thank you. Thanks, Chair.
Senator O'Donnell.
Thank you, Chairman. Welcome everyone to proceedings. Can I just take up a couple of points? Firstly, with say the IFA, and you might just, because there's a lot of abstract on this area, in your dealings with the banks themselves, we're being told by many customers, business customers, that there's constructive non-engagement by the banks in terms of looking at restructuring loans because they have the backstop of selling to the funds. And it's a form of moral hazard in its own right. So you might just tell me about your engagement with the banks themselves and whether that view of constructive non-engagement is actually a reality. Because they effectively have the default of the selling to the vulture funds.
I think, Senator, the first thing to say is that engagement with the banks differs. So you have the banks who are selling the loans and the bank who hasn't sold loans, working its way through.
There's very few of them now that haven't sold loans left. There's very few of the pillar banks that haven't sold loans left.
Working through their non-performing loans. And dealing with that bank is a very, very different process than dealing with the bank where the loans are being sold.
So you're talking, I'm assuming you're talking about Bank of Ireland, am I correct?
Yeah.
Okay.
In the banks where the loans are being sold, well, I think that one of the pillar banks is now seems to have their non-performing loan book sorted, in what we're dealing with anyway. And the other where I'm talking about an AIB, it's a painstakingly dripping slow process.
So who would you believe has their non-performing loan sorted at this point?
Ulster Bank.
Okay.
From what we see, we don't, by and large, Ulster Bank loans have been sold.
To Cerberus? To
Cerberus, well, AIB are in the process of sorting out their non-performing loans. And
to every day?
We can only go with what we have.
We're talking about the sale to every day?
Yes, one sale has taken place, and according to you go with what you read in the media, another sale is being lined up. But in dealing with the debt cases in that bank, it's painstakingly slow. You're entering into a process and you're left continuously wondering, is it a process that works at all, and is the process itself being used to deflect from the possibility of doing a deal?
Well, in your opinion, Mr. Stapleton, do you believe AIB are using the process to effectively delay any solutions until the loans are sold to a fund?
I can certainly see how anybody would come to that conclusion.
Okay. And in your dealings with the funds, right, and obviously Cerberus have been the one that would have taken a lot of the farm loans, how have you found in dealing with the funds? How have you found it in terms, I know you made reference earlier that you're not dealing directly with the funds, but have they done deals? Have they restructured loans for farmers? Have they appointed many receivers? How has been your engagement with?
So long-term arrangements are not an option when you're dealing with the funds.
And what do you define what's a long-term arrangement?
A long-term arrangement is whereby
how long?
We will pay back this over 10, 15, 20 years.
So what typically...
to be fair, they will give time of, what I would say, 1 to 2 years to put in place an arrangement. And give the opportunity to sell the particular property, and on that basis then they will tell the borrower to go
and refinance.
And refinance with a different bank.
And what are the options you're finding for your members available to refinance?
Much more difficult than you would than an ordinary member who has no sold loan. It's much more difficult, which brings down again the level of a sustainable loan that they can get in that refinancing process.
Do you have a suspicion that the name fund is a bit of a misnomer, that effectively they're 100% geared or 100% borrowed? They're effectively asset disposal agencies as distinct from funds. So effectively they're borrowing the money 100% to buy the loans. They have to get the money back quickly.
They're using venture capital to buy the loans from the bank and to recover the maximum possible profit on that.
So they're not funds?
Well, I don't know.
I just think I brought this up before. I'm getting it from people out there at the moment.
What they are not is a lender, and they have no interest in lending money back to the borrowers.
Okay. Like, we need to cut to the chase here. Part of the problem here is that many of the funds are not funds, in my experience. Many of the funds are effectively asset disposal agencies that had borrowed on the markets, be it from vulture funds, from funds or whatever, and they themselves have to repay the loans back quickly. By definition then, they're not structured. So are you finding that they're doing any long-term restructuring of loans?
None.
None?
In my opinion, none. The only long-term restructure that's available is to go and refinance with a different bank once you get the debt down to a sustainable level.
And would you... Yeah.
And there's a couple of things I would correct.
Yeah.
A lot of these funds are pension funds.
Our
investment funds are managed funds, largely abroad, because that's what, here are the websites. Everything is geared towards the reason you should invest with us.
It's a slightly different thing, Mr. Kassan. The money that's used to purchase the loans comes from pension funds. But the vehicle that purchases the loans themselves have borrowed money from the pension funds. It's a subtle difference, but it's an important one, because if the money was purchased, if the loans are purchased directly by funds, which are pension funds, they would have the capacity to do long-term restructures.
I mean, the elephant in the room for the businesses, and I would probably include the farms here, because there is with absolute certainty an issue. A proper GRG investigation needs to occur in this country. Without a shadow of a doubt, assets have been sold by essentially a structured default. Absolute certainty of that. I mean, I have a client...
What do you mean by that, Mr. Kassan?
Basically, I have a client that had 40 apartments, and the tenants had the receiver's letters before he had any indication it was coming. And they made a bid on the asset of, and to take an example, I don't want to this on public record, I don't want to make it too close. So he offered $6 million to buy the assets. And
from
the fund? From the bank, sorry, it was still a bank at this point, with the bank.
Are you comfortable to say which bank it was?
No, it was sold at a later stage.
One of the pillar banks?
It would be, yeah. So it was sold at a later stage for $4 million. After as the asset holder, the owner of the loan, offered $6 million.
To the fund? And you know for definite it was sold for $2 million?
For less, without a shadow of a doubt.
And did you inquire?
And there is also, in that particular case, missing rent with regard to the receiver.
And was that sold as a bundle? Was that $4 million sold as a bundle of larger loans within...
No, the asset was sold for $4.
The asset was sold for $4?
Yes.
But was that sold as part of a bundle? Was that sold as part of a bundle?
I don't know. No, I'm saying at the point this was actually done, it was still with the bank, from memory.
Okay.
I'm just saying that you can structure a lot of these things. I mean, a lot of the moral hazard aspect is all to go over to the customer. And I don't see the examples that the banks are talking about. There's absolutely people that overextend it. If that's where the moral hazard is, we probably all did. But it's how to resolve it that nobody's looking at, and the state is absolutely losing out here, as much as anybody else. I mean, for example, right now at this minute, another bank, if you have interest only for 10 years, I saw a loan offer, I have it in my office, where the term of the loan was for 12 years, the amount borrowed was for 480,000, so you immediately know they're elderly. They were interest only for 10 years at 500 and something euros per month, and then it was to go to 7,500 per month for the remaining 2 years.
How could anyone write such a loan?
Now, the bank will tell you how could anyone accept such a loan. This is the defence they'll keep throwing to me. And the solicitor advised you, and this advised you. That's what you get thrown back. And I'm saying, hold on, who underwrote this loan? And I go back, and I've said it in this room before, the branch manager in 2007, Burke, I have to get 7 million out that door every week, and they don't give a damn how I do it. One important point I would make with regard to the farmers, one issue that should be challenged to existing pillar banks, local branch managers who have known these families for years, the responsibility and the discretion they have to do arrangements is gone. It is now all thrown to head office. This word head office is used everywhere. That is a huge issue here. That the responsibility that the local manager who could take the chance that he previously took with a farmer is gone. It's now an underwriting department, hidden people, for want of a better way of putting it.
Can I just hit? Yeah.
Mr. Stapleton wants to.
Oh, sorry. Yeah.
And Mr. Kieran actually made the point I was going to make, but just to add on to it, I've had local branch managers tell me that commitments that they have given verbally to their borrowers have been reneged on by their superiors.
Okay.
Okay, that's just an important point. I think.
Is that with the pillar banks?
Yes.
And can you say, are you comfortable saying which bank?
I don't know. I'm going back to the chairman's comments here to start.
I don't mind me.
It's not going to add any value.
It's one of the pillar banks.
Yeah.
Can I just a few quick questions? With Cerberus, which are really the main example for the farmers, because Ulster Bank would have had a lot of farm loans and lots of SME loans, right? Have they sold any farms or land? Have they got appointed receivers where they're effectively sold the family farm and the home to date that you're aware of?
I think most of you will have seen on the press last month where we took a stand in County Meath, where an online auction proposed to sell. We had put in that case a strong argument that a really good offer was being made. Negotiations through Cerberus, negotiations continue on that case, but at that time the sale was postponed. So they're selling. They would argue that they don't know enough of the detail. Information around what is actually happening is very, very hard to fully realise, because there is no knowledge, or we have no sight of what information is transferred from the bank to the fund, what information the fund is entitled to talk to us about. You know, I've seen a case again where a borrower asked from a pillar bank for all of the information around his loan, and he got a huge folder with half of the stuff redacted inside it. It's very, very difficult to understand how pillar banks, which are, you know, partly are all owned by us as taxpayers, are behaving in such a manner.
And what's your ask of today?
Our ask is for protection for the borrower, to go back and make the environment where somebody who has a bad debt can go back, put a sustainable loan in place in accordance with the repayment capacity of that farm, so that people get the opportunity to work their way through their debt in all cases. So we put in there as proposed solutions that the personal insolvency legislation would be adapted to farmland in the same way as it's adapted to dwelling houses. We suggest that the interest that the fund would charge, where they are charging interest, would be to offer them a return on their investment, rather than to return or to charge an interest on the actual amount that was borrowed. I think that's important, because if the fund is buying these loans at 30% and the bank was charging 6%, in effect the fund is charging 18%. I think it's important to understand. Finally, I would say, to stop the AIB loan sale, I think that's something that for the community at large would be far better off, and get our own bank, the bank that we as taxpayers own, to work through their debt themselves for the best interest of both the borrowers as well as the bank. And to go back to Mr. Kieran's point, huge money leaving this country as profit, tax-free, money that could be made available to other borrowers for growth and sustaining this economy into the future.
Thank you. Just two quick questions. Mr. MacDonald, in your submission you made, it's clear that the witness that was going to company was going to appear, currently would not be honoured if the company appeared before you. And then you give an example, Company A. Company A had a loan with Ulster Bank, and it was sold to a fund, receiver was appointed, it was made clear that my appearance at this committee would result in a withdrawal of the offer. So it's Company A and the person you're referring to in the second, all into one. So it's Cerberus. And how have you...
Well, it is one of the known funds to which Ulster has disposed of its...
Okay. And how have you found dealing with the funds on behalf of your members?
Well, perversely, and so this question has been asked a couple of times, there has been an element of debt forgiveness in that case, but it's fast turnaround. So we want it resolved. We want it resolved now. This is on the table, and it's take it or leave it stuff.
Refinance.
Yes.
Okay.
And with the sale of a family home, you see, that's the issue. So there is. I did try and give you two flavours of this.
Fine.
The second one is IBRC lending, which went to another very well-known fund. And there's an expectation, and they have been 100% paid back over. They have been 100% paid back at though the effective cost of the liquidation of the business and all the employees within it. So there are different ways of looking at this, you know.
And finally, Mr. Kassan, you made reference to about we were with the ECB, with a delegation to the ECB in the last number of weeks. We met the ECB on the restructuring, particularly of home loans and loans. And what they said to us, their only instruction was not on the MPLs. They did not put a defined time as to when they want the MPLs brought down. They wanted loans put in place that were sustainable. So if a loan was 200,000 and that only loan in that element that was sustainable was 100, they wanted 100. They weren't too worried about over how many years, depending on the age of the person, and that 100 would be parked in junior and senior would be the 100% sustainable. Junior would be 100% unsustainable warehoused. Are you finding that the banks are doing that, or are they being quite deliberate in only willing to restructure loans to a certain percentage of the loan, 75% or so? They were quite insistent. In fact, the ECB were quite frustrated by the banks that they felt that they were being blamed for the time period when the MPLs being brought down, and they just want to see sustainable mortgages. So your experience of that with the banks?
Well, the common answer you hear from all the previous presentations by the banks, we don't do debt forgiveness. I mean, it's the greatest joke of all time. We don't do debt forgiveness. Every one of them have said it in this room. I've listened to them all saying it, because they don't want to put it out that the other 90% of their customers are all going to stop paying their mortgages because they do debt forgiveness. I mean, it's just a complete fallacy. The issue here is, like, one of the difficulties with a vulture fund that is now actually only starting to become known is if you sell all these loans, first of all, the customer can't borrow. Secondly, he can't do an extension, or he can't do a trade, an improvement on the home. So the economy and all the small builders that would be getting those, all gone, because he can't borrow a cent extra till the mortgage is paid off in full, irrespective of the arrangement. So until he pays that mortgage off, he's stuck. And especially if it's on a tracker rate, he can't move at all. And the two examples that I gave, and they were most certainly, those cases were put in to sweeten the deal for whoever was purchasing the loans, because they have never missed a payment. And I heard that same bank tell this committee that no performing home loans were sold to vulture funds. That is factually incorrect, and I have two clear examples that can prove it. The second issue with what you're saying is there's so much confusion put out about it. It's nearly almost deliberate to create the confusion. But what the banks have decided, as they're about to embark on this new culture shift, is move the problem to somebody else if we have to bring somebody to court. Let not it be us, because our reputations are damaged enough that we won't bring them to court, we won't take repossession. It's that bad vulture who doesn't care because he bought it for 30 or 20 or 40% of the original value anyway. And that's their game. So them in front of a court is second nature to them, because that's part of what they do, asset disposal. But the bank to do it here, and it's also extremely difficult to get repossessions and so forth, and it's nearly dirty. And that is a contributor to the problem of the difficulty of getting repossession from factual, let's say, strategic defaulters. The problem is all of the figures, and the other thing that I would always ask about is who is describing what is a strategic defaulter? The very same lenders. Now, the facts of it is, and David Hall will tell you this, A strategic defaulter, according to the bank, is one who isn't paying the full loan mortgage to his lender and may be paying something to his credit union or his other personal loans or his overdraft facility. He's classified as a strategic defaulter by the domestic home loan bank. So the definitions for everything that we're discussing here are also coming from the same banks. And remember, we believed them before when it came to a banking bailout. And here we are starting to believe them a second time.
Thanks, Mr. Castan. Senator Burke.
Thanks, Chairman. A few brief questions. I'd like to welcome all of the delegations. Just to ask Joe in relation to the percentage of loans, farmers' loans that might have been sold to vulture funds. Do you have a breakdown of it, or do you have a percentage of the loans that might have been sold to vulture funds?
We don't.
No.
We don't.
Because Neil said that there's about 10% of businesses that have been sold to vulture funds. On the other hand, we see where the farming organisations are helping, we'll say where vulture funds are trying to get control and take over, and you see farmers campaigning and that. But we don't see the same type of campaigning, we'll say, done with the small businesses, where small businesses in difficulty. We don't see that the ISME is helping out, we'll say, where their loans and businesses are being sold to vulture funds. Is there any campaigns that's carried out at all by ISME to protect, like Paddy is doing with the non-performing loans for mortgage holders and that? Has ISME any plan at all to help the small business?
The issue with the small business sector, Senator, is the fact that among all the trade associations, our penetration into the total SME market is a decimal of it. I'd say if between us we have 40,000 of 250,000 businesses, we'd be doing well, and we tend to have the bigger ones. So there is a real difficulty in getting anything like that to happen, and there's also a real difficulty in getting our members who have these debt issues to come forward at a time when you can actually do something about it. And realistically, when you get into that long grass with the fund, realistically, we're going to require the services of people like Mr. Kazan, because you're going to be dealing with this on a case-by-case basis. It is very difficult to present a united front among a lot of small businesses. And bear in mind, quite a few of the things I would deal with actually have unfortunately have quite complicated debt structures. So you have a small business that might have a family home or family land or farmland or farm outbuildings or mobile assets that are part of a deal, a cross guarantee on another functioning business or another illiquid business, for instance. So unfortunately, the types of guarantees that people get into, if they saw down the road what would happen to them, they probably wouldn't get into those in the first place. But however, it can be extremely difficult to resolve those down the road.
Yeah, well, we have seen from a lot of business people desperation where they had to sell their businesses, where they couldn't even draw social welfare. And I find it hard to believe that ISME hadn't some sort of a plan, or that you haven't found that those type of people have gone to you in desperation to seek and help. Are you saying that the fact that you have no plan would mean that you haven't discussed it really, or have you discussed it? Or did you decide not to put a plan in place to help those people?
What you see publicly on our website, they are the issues that people bring to us. Thankfully, this isn't, of the 10,000 odd members we'd have, this isn't an issue for the majority of those people. We're
10% according to yourself, which is sizable enough.
Yeah, so when we survey people in the bank survey, we say, I deliberately put in the example of an overdraft because that was the first one I had heard of it. Debt comes in many forms. There's very long-term mortgage debt, there's short-term business debt of 5 to 7 years, and then one thinks of an overdraft as a very short, generally less than 12-month facility like credit card debt. But all of those are in scope if your bank decides that they want to liquidate an asset. If we will come up with a policy on this if there is an upswell of a persistent demand for one type of issue to be dealt with by the membership. But I mean, the fact that I'm here today, and even as an organisation, we're constrained in the presentation we were going to make to you. I'm not really sure what you're after, Senator. We're doing our best.
I would say that in the case of the farming organisations, they would help a farmer, whether he's a member of the IFA or not, that the members of the IFA would bandy around some of the members if the guy that was his property was.
Yeah. I think, Chairman, look, I think one of the challenges with all this is that, I mean, I think there's a huge amount of people here suffering in silence here, because it's a very big decision for somebody to come to, whether it's ISMA or the IFA or any third party, and reveal the problem they have here and seek help. So, I mean, we obviously have a clear plan in terms of how we help people, but I think that's one of the big issues that's out there, is the number of people who are suffering in silence and haven't looked for help off people. And to come to an association, you know, there's obviously we have a team structured. You can go to somebody in your region, or you can go to somebody outside your region if you don't want that information to be known locally or publicly. So I think that is a factor for all representative bodies in matters like this, is the suffering and silence factor. And it makes it harder to get a grip on it, just how big a problem this is. But I think, looking at it, we run campaigns every day and every week on various issues. And the reaction we get from our members on this type of issue is huge. We look at the hit rates on our websites, on stories, we monitor all these things. And from looking at that, you've got to think that there is a huge number of people out there who are worried about this, who are on the radar, who are in trouble, and are not sure where they're going to end up. I think it's you know, it's a concern as well that, you know, we would meet farmers who, when they eventually come to IFA, sometimes it's too late. A lot of problems have arisen, and they're afraid to come as well, because they feel that if they come to somebody like the IFA and maybe the case becomes high profile, that the fund will be harder on them, and that's a factor as well. So for us, it's hard to get a grip on just how much of it is out there, but based on the reaction, I think we'd be very worried now that there's a lot of farmers out there who are you know, in trouble here.
I have to interrupt you because we have a vote in the Dáil, so I have to go.
Okay.
And Deputy McGrath has to go. Could I just put on record with you here, and maybe Senator Burke might chair when I'm gone, if you wish. But I want to just say to you that this morning we heard from the departments in relation to receivers, and what was said there in terms of the unregulated and unaccountable receivers has been borne out by what you have told us. Secondly, we have said time and time here again about vulture funds and how aggressive they are and how they should be stopped in their tracks, and the need for a political response to that from this House, which seems to be slow, very slow in coming. The type of legislation that's needed to be put in place. It's almost as if the political system is in paralysis and in fear of bringing forward the type of legislation that's necessary, often spoke about by the Master of the High Court. So, we have a number of players here this morning. First of all, the IFA is an organisation that is one of the last men standing in society today that has huge commitment from its members and is highly respected and is well used to campaigning. ISME likewise, and it's an astonishing statement in your opening statement, Mr. MacDonald, that you would have been prevented from making the appropriate presentation here, which underlines how bad the vulture funds are. You too are an organisation, you know, well rooted in the world of commerce in this country. And Mr. Kassan, you know, you mentioned David Hall a number of times in your contribution this morning, and due to personal circumstances he couldn't be here. But both you and David are well respected throughout the country for the work that you've been doing in the context of defending those that are in trouble. And I admire each one of the two organisations, and David Hall and you, Mr. Kazan. I hugely admire the work that you do. But here's the problem. I think it was the 15th of March, we laid before the House a motion which was put forward by this committee in relation to the Vulture Fund's non-engagement with the committee. And we compared their engagement with the department over the years 2013 to 2016, where it had 125 engagements with the Department of Finance. Now, they continue to have engagement with the Department of Environment, Local Government Environment, whatever the title is now. So this was the motion. The government were defeated in the context of the amendment to the motion that they put forward. So we spoke about the lack of engagement from the Vulture Funds. We spoke about the unsuccessful attempts to get the agents in, the agents that represent those funds in to be accountable to Parliament before this committee. We also were calling on the unregulated investments funds and regulated creditors to attend the committee. That was supported by the central bank, and the central bank said that firms with a serious role in the Irish economy have a social responsibility to account for themselves before the committee. We then went on to ask the government to cease all engagement with unregulated private investment funds and unregulated credit services firms until these entities were accountable to Parliament. Now, we're talking specifically here about Vulture Funds and their activities. And lastly, then, we asked for legislation for the regulation of the unregulated entities. Now, the reason why I'm prompting you to look at the scope that you have within your own organisations and to understand the respect that you have is, I believe you should take that motion, which was passed in a cross-political party here, our effort here to bring focus to this, and you should lobby the Minister for Finance, as we do. I would encourage you to maybe collectively ask the Minister for Finance for a meeting to bring a stop to this. It's causing destruction of families, destruction of family farms, family businesses, homes. It has led to suicide, let's be straight about it, and it's continuing to have a major impact negatively on our economy. So I don't want to leave the meeting without creating some sort of step forward. And I believe that you bring a certain credibility to the story, because you have heard those stories from your own members, or Mr. Kazan, the people that you interact with. Please don't leave it here. We won't leave it here. We'll take it forward to the Minister. But in the name of Ireland and the people that we all represent, please join in the campaign to stop these vultures. Because the political system and the political parties have an unwillingness, a fear, whatever it is, to actually openly deal with it. But they have the capacity to deal with it, but they refuse to do so. So I'm just asking you, in terms of concluding the meeting, let's not leave it here. Let's take it from here, and please make it part of your agenda, going, in your engagement with government. Mr. Healy, you have, a significant position within the country, as has ISME, in terms of your organisations. Don't underestimate the respect and the power that you have.
And I take what you're saying there in your recommendation, and yeah, definitely will. And we have no intention of just leaving it here today. This is a long campaign that IFA are involved in, and deeper we're getting into it because, as Damien said, there are a lot of our members that are either too shy or too embarrassed to come forward. But I do think that the government could play a role, and Martin mentioned it earlier. This sale that's going to come forward from AIB, the government can't wash their hands out of that. They can prevent that from going ahead, and I think that we can't state strongly enough here today that they need to do that.
Well, perhaps the message from this meeting has to be stop the AIB sale as a marker.
Yeah.
and then get into discussions with all of the representative bodies and advisors such as Mr. Kazan.
Can I just make a comment? The 4 people that were brave enough to come forward with me about the tracker issue and the effect that had, the difficulty with, and I said it here before in one of my presentations, that a lot of what is going on, they're using our Irishness against us, is what I stated. And what I mean by that is there's an internal shame to missing or not being able to pay your debts in Ireland. It's built into the makeup of the fabric of all of us. And the concern that I have here is the vultures know it. And they know damn well nobody's going to come forward. And I have even spoken with different TV companies about silhouetting people, and I've been told that to make them look like the criminal. And I said, but they cannot put their faces to the camera because they'll be known forevermore. It's a small country. The point I'm making here is maybe it might be appropriate for the committee to get some of the examples of the people that are brave enough again, another 4 to come in about the issues, an ISME representative that is saying and stands up and said, I don't care what I've signed, I'm going to tell the story and how it happened to me and the farmers. But it is so difficult to get, and that 4 people summarises how difficult it was. But look at the effects of when they did, and I think maybe to pass out to the customers that are affected that there are people here that will stand by them and go shoulder to shoulder with them. I say to every client that comes into me, it's not solved today, but it's shared.
Well, can I say to you that we did try to do that. We did try to do that. And the reason why the meeting is structured the way it is today is because in the different people that we approached, they were actually afraid to come before us because of the nature of the letters and so on that they had received from banks and vulture funds. And that's why I'm saying that's the broad message in terms of AIB, and the broader message still is to government to step in and do something about this. That's what I'm asking.
Chairman, can I just say, and I think it should be put on the record, that there was one person willing to come forward. He sent a statement and he was supposed to appear today, Noel Howley. He circulated a statement to the members, which was circulated by the Secretary, and he has lost his business. He never missed a bank payment, and he has lost his property. And I think it's an absolute disgrace when you read through his submission that was made here to the committee. So I think it's worth putting on the record.
Well,
I welcome the statement.
We'll put that statement on record, and we'll ensure it's acknowledged.
Say with confidence, there are more and more people starting to become, let's say, brave enough to come forward. More and more are starting to say, "I'll go public for it," etc.
Okay. Well, let's just say from this meeting this morning that having listened to all of you, that invitation is there for people who have been badly treated by banks or vulture funds or want to share their experience. There is a forum here, this is it, to please come forward because you would be, giving some support to those that are in fear of coming forward, and we might get a greater picture, a broader picture.
And Chairman, can we get the message from this forum and this committee here this morning in relation to the sale? Of AIB sale.
That's what we're saying.
Yeah.
We've asked for the sale to be stopped.
Yeah.
So we'll pursue that.
Okay.
And thank you very much. Sorry.
Just to clarify one point, because somebody raised it earlier in the discussion, what was a non-performing loan? As I understand
I've missed a vote now, so if the government falls, it's your fault.
I take that.
You're looking for an election anyway.
Yeah. You'll be thanking me so. But just as I understand what non-performing loans means when it comes to the sale of loans is any loan that's 90 days in arrears or any loan that's connected to a loan that's 90 days in arrears is a non-performing loan, plus any loan where a bank takes a view that is unsustainable without a secured asset sale. And I think it's a definition that's way too broad.
But to be honest, Mr. David, the banks just define it as they wish. Is my opinion. Can I just say one last thing to you? I also know that banks, before they sell, in terms of their sale to the vulture funds, they can often restructure and the client feels comfortable about it. But they overlook the fact that the structure or the restructure is only for a 3-month or a 6-month period, thus leaving it open to the vulture fund when the sale is complete to review it in 3 months or 6 months, and they find themselves then in a very uncomfortable position. So,
in regards to, you mentioned, one of the President mentioned earlier about the fees paid between the agencies handling the debt.
yeah.
I mean, in my own other industry of the life insurance financial services, commission disclosure is there in statute. You have to do it to the customer. There's a hidden issue going on in here of bonuses and so forth that, again, nobody knows about. And the fees in this area are astronomical. But then when you add in the main players on the accountancy side, and there's more Chinese walls in Ireland than there'll ever be in China, from what I can see, because they're now the external, the internal, and the firm that is handling all of this, but they're doing all of this other stuff with regard to tracker investigations and stuff. The whole thing is connected.
we'll have to leave it at that, Mr. Gassan, but we will come back to the subject again. Thank you very much for attending the meeting. As I adjourned until 23rd of October.